All right, everyone, we're gonna get started here with the training for today. Thanks for joining us. Glad we could get up here to visit you all in person, and for those of you on the computer joining us remotely today, wish you could be here, and hopefully someday we'll all meet you in person. My name's Dan Deacon. I am a partner in our Washington, D.C. office. Our law firm, Conn Maciel Carey, we specialize in OSHA workplace safety, labor and employment, and some mine safety as well. So this is what we do. We live and breathe workplace safety and OSHA. Today's training, it's going to be a little bit of a combination of some trainings that we provide. One being the OSHA Bootcamp, kind of giving a synopsis of the OSHA Act, some of the enforcement tools that OSHA has at this time, some of the new enforcement tools. A little bit of some data on the enforcement history side of things. And then we're going to dive into record keeping and reporting. And at the very end, we're going to touch base on the record keeping piece. So we have an agenda slide that will cover all that, and a couple slides here as well. You're going to receive all of the materials here, the slides. We also have a record keeping and reporting primer, some materials that you all get at the end of this. And the presentation is being recorded, so you all have access to that at any time afterwards. So we're hoping for this to be an interactive session. If you have any questions along the way, just raise your hand or feel free to shout out. For those of you online, we have the chat function. Feel free to put any questions, comments in the chat, and we'll try and check that periodically and chime in. If not, we'll have some periodic breaks where we can have some discussion, and we'll cover some of those questions in the chat as well. So just another brief introduction. Like I said, my name's Dan Deacon. I'm a partner based out of our Washington, D.C. office. I've been working at the firm for about 8 years. I work in both our OSHA and our labor and employment group. Work predominantly with the OSHA group, handling inspections, workplace catastrophes, all that kind of stuff, and then general advice and counsel, helping put together workplace safety and health policies. And then on the employment side of things, we do a little bit of wage and hour discrimination work. And then I'm joined today by my colleague, Nick Scala. If you want to introduce yourself.
Hey, good afternoon, everyone. So Nick Scala, pleasure to be here. I am a partner in the firm as well. I'm based out of our Ohio office. Was in DC prior to that, but I think probably, as you guys all know from working with Dan and Rachel previously, we're kind of just all over, right? You know, it's home base. It's where the bags get packed and you go out. But so I represent companies on the OSHA side and then on the mine safety side. So I am really just kind of a workplace safety specialist in that. Look forward to kind of covering with you guys today. Anything that comes up, anything that arises, questions. We're going to go through a lot of information. Don't let two attorneys talk at you all day or all afternoon, I should say, and interrupt us, interject, ask questions, and we can work through any of those scenarios, or at least have a good discussion about it and then work to get you a better answer afterwards. But appreciate the opportunity to be up here with you, and I'm looking forward to it.
Yeah, thanks, Nick. So yeah, just a little bit more about our firm. We have about 23 OSHA attorneys throughout the country: California, Washington, D.C., Columbus, New York, North Carolina. So we basically cover every jurisdiction. We've practiced in every state, and that's what we do. We're one of the larger OSHA firms in the country. And I'd like to tell you how I got into OSHA. I really don't know. I was in the employment group at a larger firm beforehand, and one of our founding partners of this firm just said, "You're going to do OSHA now." I had no idea what it meant at the time. 8 years later, that's my specialty. So maybe at a break, you can hear how you all got into safety and health. But interesting kind of how we all get to where we are now. So again, the agenda, this I kind of already touched on. Nick's going to cover the OSHA enforcement trends, data, and I'm going to cover some of the rulemaking pieces and interject here and there. Nick's going to cover managing an OSHA inspection. What happens when OSHA shows up at your door unexpectedly, right? How do you manage the inspection? How do you interact with the compliance officer and, know when to seek help or when they're might be some red flags that you need to pay close attention to. And then we're going to transition into the OSHA record keeping and reporting side of things and conclude it with a brief review of OSHA's updates to the e-record keeping rule and those data submission requirements. All right. So with that, I'm going to turn it over to Nick, and he's going to go over the OSHA Act, OSHA, and some of the enforcement trends that we've been seeing as of late.
All right. Well, thank you, Dan. I guess to follow suit, talk about how we got into what we do. Mine's a little different of an approach. I got into workplace safety and health law because I grew up in a family business my dad and his brothers ran that was construction and mining. So I worked in that, and when I was in law school, you know, everyone likes to get paid in between their school years. So I was trying to find a paid job and fell in with an attorney who did mine safety and health work and OSHA work around the country. And that's really where I got started and haven't looked back. So I like to talk about, you know, I learned about the regulators at the dinner table because that's usually when my dad was in a bad mood. If they were showing up or calling in because they had to come down and do an inspection in the middle of the night or something like that. So that's a bit about how I got to where I'm at. But, you know, when we're talking about the regulations, you know, we're going to start off, and it's probably going to be things you guys know, or maybe you don't know, but, you know, let's start off at the bottom, right? You know, where's beginning is a very good place to start, as they say. So how do we get to OSHA, right? It was the OSHA Act, the Occupational Safety and Health Act. That was passed in 1970s. And it was intended to assure the safe and healthful working conditions for working men and women by authorizing enforcement of standards developed under the Act, and by insisting and encouraging the states in their efforts to assure safe and healthful working conditions. So there's some other parts to that. You know, they fund research, develop information, develop compliance tools, things like that. But the OSHA Act is what created OSHA, and especially the OSHA we know today. It's what gave forth the creation of the standards that regulate us. And, you know, this is a directive by Congress, right? It is a law. So that is kind of the foundation of where we are, how it begins and where we go from there. So, you know, the primary things, right? Safe and healthful workplace. We all share that goal. But, you know, OSHA, it specifically says there, is by authorizing the enforcement of standards developed under the Act. So then we kind of look at what are those enforcement provisions? What are those tools? Well, we're going to have specific standards. And, you know, you guys are probably familiar with specific standards apply to the workplace, right? That affect you all, whether it's with powered industrial trucks or it's on the reporting side or health. But a big one that OSHA has that we, you know, have to be considering of is the general duty clause. And that's section 5A1 of the OSHA Act. And why is that important? Because it's, OSHA's catch-all. It is the provision that says each employer shall furnish to each of his employees a place of employment which are free from recognized hazard that are causing or likely to cause death or serious physical harm to his employees. So what does that mean? In short, it means if OSHA comes out and finds a condition and they don't have a standard which specifically regulates it, they can still try to issue enforcement under the general duty clause. Right? It has to be a recognized hazard that can be recognized by the industry, by peer organizations in the industry, by industry associations. You know, could be something that you guys have recognized as a specific hazard to your operations, to your locations, and it may not be specifically covered, but they're using that as a recognized hazard there. And maybe you have not done enough to protect against it, in their opinion. There's a lot of ways it can go. This general duty clause is a kind of a catch-all again, because if we don't have something specific, they still have the opportunity to come after us with enforcement. And part of the problem there is with the general duty clause, and why it is something that we have to monitor and walk throughout is, you know, we can see these specific allegations, and maybe it is something that is we've been doing its best practice, or is a recognized best practice, but maybe not applicable in every situation. So when you hear that term, it is not a separate and distinct standard over a specific topic, more of a catch-all. Do you want to add something?
Yeah, the only kind of thing I want to emphasize here, there's two big topics that OSHA is enforcing under the general duty clause: heat and workplace violence, right? those are two topics in which there's kind of a push right now to formulate a rule. Heat is much more along the way, I would say, than workplace violence. There's workplace violence in healthcare rule that's being proposed and worked through now. But those are the two kind of main topics that we see enforcement under the general duty clause, but there are a host of other issues. And what Nick was saying about, it needs to be a recognized hazard. One of the ways in which OSHA can demonstrate that it is a recognized hazard is, guess what, in your injury and illness records, right? If you have a host of injuries related to perhaps a hazard that isn't covered by a specific regulation, that is knowledge, right? That's attributable. You're recognizing that this is a hazard, it's caused injuries, and that can lead to enforcement under the general duty clause.
Yeah, that's true. It's where those records can really, the record keeping part in determining what's included, what's reported, what's recorded, all that has to be a serious consideration, which I know Dan is going to talk about in depth later as we go. The other kind of specific duty is section 5A2. That says that you have to comply with the provisions that are adopted in specific standards, right? So what are those standards? We're looking at the 5 major categories of record keeping, general industry, which is going to apply for you all, construction, maritime, agriculture. Those are ones where we have specific regulations promulgated and developed by OSHA. Then they also fall into categories of if they're safety related or if they're health related. And a lot of times when we're having different kind of inspections or different kind of visits from OSHA, they are going to be focused on, that safety side or that health side, depending on what the kind of investigation or what the root and nexus for that occurring is. If it is due to an injury or if it's due to occupational illness or hazard complaint or something of the nature, they'll be looking at, whether or not this is going to be more safety related or health related, and they have standards covering both. So those are areas that you look. And why is that important? Because eventually the option arises that OSHA can come out and they can be doing inspections or investigations at your guys' work sites. Again, this is a provision that is specifically called out in the OSHA Act. It gives them the authority to carry out the purposes of the act. The secretary, upon presenting appropriate credentials to the owner, is authorized to enter without delay at reasonable times and inspect during regular working hours and other reasonable times within reasonable limits in a reasonable manner any such place of employment and all pertinent conditions. That's a lot of reasonable questions, right? A lot of reasonable classifications. And what it's looking at though is they have the authority to come out and conduct investigations on their work site. Can they show up in the middle of the night and demand you guys be there? It's going to have to depend on the circumstances, right? It is going to be looking at the conditions that they're investigating, the times that their conditions are allegedly present if we're working multiple shifts. But they do have the ability to come out and the mandate to come out and verify what the safety and health status is at your places of employment. Now, we don't see, OSHA inspections regularly necessarily. Sometimes we can have a place of employment that doesn't get one for years at a time. But when they do come, when those do initiate, they're going to be looking at your facility. They're going to be going through, they're going to be somewhat targeted at times, maybe looking at specific items, or they could be looking at kind of a soup to nuts, wall to wall inspection of the entire site. And that's something that we'll talk about when we're going through the managing the inspection process, where we're going to have those discussions with the compliance officer at the beginning and try and figure that out. And if we need to discuss narrowing at that point in time. So as a process of this, what's the kind of the next item in that kind of chain of events? It's enforcement. And we'll take some time to walk through this, but it is the enforcement arm of OSHA. So they have the ability to come out and do inspections. There are standards that have to be followed. What happens if you're not following those? It's the issuance of citations. So if upon entry, the secretary, and when they say secretary, they mean the compliance officers, right? They act as the enforcement agents of the Secretary of Labor. It believes that the employer has violated a requirement of Section 5. Section 5 is where the standards are. Remember, 5A1, 5A2. He shall, with reasonable promptness, issue a citation. In addition, the citation shall fix a reasonable time for abatement of the violation. So we have a time frame where we're going to get enforcement, right? That's 6 months or from the time of the initiation of the inspection. By the end of that 6 months, I got to be careful not to walk away from this and walk away from the mic. I'm a wanderer when I speak. So apologies for that. You're going to have enforcement issued at sometimes, not all the time, right? There's a lot of opportunities throughout that where we're going to be having, discussions with the compliance officer. There's going to be requests for documentation, requests for interviews at times, requests for other kinds of information pertinent to their investigation. But the culmination of that is if they believe that there was a violation, they're going to issue some kind of enforcement. At that point in time, then we also have to be looking at what the abatement period is on it. Abatement means correction of the hazard or correction of the perceived hazard by the compliance officer. So we want to look at that. They're going to tell us what they think that is. That does not mean we're bound to it, but we need to pay attention to it. We need to pay attention to what that is and when it says and what our obligations look like, because as we move through the process of determining how we're going to respond, if we're going to contest it, how we're going to contest it, what we're looking at there, we should be paying attention to those deadlines as we go. Yep.
Question, did you say that 6 months begins with the initiation of the visit?
When the investigation is open.
When it's open?
Yeah.
And are they, is OSHA obligated to officially tell us at some point, or do the 6 months go by and we don't hear things from them and we assume it's done?
So
Yeah, so that it varies, right, depending on the situation, right? If you're looking at perhaps a reporting citation, what is the 6 month statute of limitations there? It's when OSHA knew or should have known of the violation, right? So if it's a late report, the statute of limitations would begin on the date that that report was made. If there's some type of accident or injury that's reportable to OSHA, they're likely going to be there within a day, right? And the 6 month statute of limitations is going to begin at the date of the hazard, basically. It's not necessarily, you'll see on OSHA's establishment search page, there's a date that the inspection is open. That is not necessarily the date in which the statute of limitations begins. So there is some gray area there. So yeah, for purposes of calculating the 6 months, don't rely on what OSHA tells you the date of the inspection when it was opened. Don't rely on that date. That's where.
Do you want to clarify though about when it's, I think, did you have a question about when it's ending though? Do they have to notify you that it's ending?
Which we had was, or still have, it was initiated from a reporting obligation. They called us, we did our thing. There's nothing that at all.
And was that an investigation or was that a RRI response?
Yeah. So there's a variety of different ways in which OSHA can respond, right, to a report. The RRI response is one of them. And sometimes you might not get a closing conference, right? Whereas when they come on site, you're going to have an opening conference, go through each stage of the inspection. Then there'll be a closing where they say, here's the outcome. You may be expecting citations, or we're closing it without any citations. If you have an employee complaint or a report in which an RRI response is triggered, sometimes OSHA might just close the case without telling you anything.
That's what I think.
Yeah. So you won't hear from them at all. And it really varies by area office. There's no kind of continuity
You
between.
certainly don't want to call them and ask them if it's forgotten.
Right.
Yeah.
It also comes up with the question of, sometimes you do those RRIs and you don't hear from them. And then a month later, they pop back up and they say, hey, what's the status? Depending on what you were reporting in there for your corrective action. And that's probably more so associated with, if you have a lagging corrective action that you're implementing, or if you have a complaint letter and you're responding and saying, we're going to do this, or we're in the progress of doing this. I've seen it sometimes where you just don't hear from them, and all of a sudden you get a phone call or an email saying, hey, where are you at on this? But a lot of times with those, it's a submission and then a wait, and you might not hear anything.
We had one, I think it was the day before, it was 6 months. And then another one, we haven't heard back. No, you don't see, I don't see anyone with it. They wouldn't speak to it, especially with that. I would say the probably be important. Yeah, the ones that we.
Yeah, yeah, and we typically don't recommend reaching out at all. You
Don't rock
don't
the
want to
boat.
make the phone calls if you don't have to, right?
Yeah. Yeah, I mean, if they're not responding back to you, just let it lie. You know, definitely don't contact them right before the end of what you think the 6 months is and say, hey, did you forget about this? We wouldn't want to do that. Thank you, though. Good question. Good question. So, yeah, of course.
Can everyone on Zoom hear the questions? If not,
Yeah, that's a good point.
That is a good point. Did everyone on Zoom, could you hear those? Could you, okay. So the question that was asked here, yes, the question was asked, could you hear the question that was being asked by the in-person team? So I'm guessing the answer is no there. So our discussion that we just had was asking about what is the statute of limitations and how does that play with different types of investigations, whether it's one that's opened on site or if we have our RRI or a complaint letter and what transpires after that. But we'll be sure to repeat those moving forward when they come up. Yeah. Right.
my question.
You're good for now? Yeah. Okay. All right, so what types of violations do we have with OSHA? The first one, kind of the low-hanging fruit one, is what they call an other than serious citation. And so this is where they observe a condition of practice that they determine would most likely not cause death or serious physical harm, but would maybe have a direct and immediate relationship to the safety and health of employees. It is, you know, the kind of least obtrusive in terms of the enforcement from OSHA. You know, we're going to pay attention to other than serious, obviously, but a lot of times when you're looking at citations, you're getting very concerned when we're looking at serious or more serious types of violations. You know, paperwork violations, usually those are something we see as other than serious. So that's kind of the baseline as we go. And then, you know, this is going to go into the more serious violations as we move forward and the ones that we do want to pay more attention to. Okay. There we go. So, and that takes us to, if not an other than serious, what's the next most common? And then kind of next up the chain of elevated actions is a serious citation. And this is one that has a substantial probability death or serious physical harm could result from a condition. That has to do with either your practices or the conditions around the facility or the processes or the operations or something along those lines. And that is unless the employer did not and could not with a reasonable exercise of diligence know the presence of a violation. You know, a lot of times when you're looking at these, it's going to be, you know, how open and obvious was it? Were you aware that the conditions there existed? If so, for how long? Were they recognized hazards? Maybe you knew that this was an area that needed guarded and maybe the guarding came off or the guarding was hampered, or, you know, possibly if it's having to do with pedestrian traffic around powered industrial trucks, you know, did you know that this was a condition, but you didn't take adequate steps to delineate or protect the pedestrian traffic or prohibit or prevent pedestrians from walking into the path of industrial trucks? So it's going to be largely dependent on this. I think, though, if there is a risk that someone could have been seriously injured or died as a result of whatever the potential injury was, we're going to be seeing serious citations. And, you know, frankly, I think, you know, at one point in time, probably other than serious were more common than serious. It seems like of lately, Dan, and I don't know if you're seeing this on your desk as well, but serious citations are more the norm than the exception to the norm of late.
Yeah, certainly we're seeing more and more serious citations, and we're going to get into some of the new enforcement tools and the reasons why we're seeing perhaps more serious, a greater percentage of repeat citations, and with all that comes higher penalties too. But the one thing also to note, and we're probably going to touch on this in a couple slides as well, a lot of employers feel, oh, we just need to get the characterization changed from serious to other than serious. And really, it's not the characterization so much that's important as the cited standard. Because if you take, say, there's a machine guarding or powered industrial trucks, right? That's probably integral to some of your operations. if you have one of the more frequently cited standards under the power and industrial trucks regulations, and OSHA is saying, oh, we'll knock that down other than serious for you. That might seem very generous, but the next time it could be a repeat, because OSHA can use an other than serious characterization and other than serious citation as the basis for a repeat. And what comes along with a repeat, potentially $155,000 plus penalty for a single item violation, right? So if you are having a conversation with OSHA and they say, oh, no worries, we'll just knock that down, it's other than serious, you can live with it. You should think carefully about that, because it can come back to bite you within 5 years, because there's a 5-year look back period for evaluating whether a violation can be a repeat, can be characterized as a repeat. So just a practice tip there on kind of some of the tools that OSHA will use to say, oh, we'll settle this really quick, knock it down, change the characterization. Sometimes that's not good.
Mhm. Yeah, I mean, and a lot of times when people see a serious violation, that's what they're focused on. And it's an easy classification to look, right? Oh, serious, other than serious, right? Oh, that must be a big change. But Dan's right. It's not only the classification, but it is the content of it, whether it's a cited standard or the description of the hazard that's included in that citation. You need to pay close attention at the entire contents of the citation, not just whether or not it's serious. But to classify as serious, they have to consider, the type of pattern of exposure, right? Is there going to be exposure to the condition? If, you have a guard or a piece of machinery, and we're going to go back to guarding a lot because that's kind of something that's easy to put into our heads, right? But if you have a piece of equipment that's running and it's, spinning and there's a guard on it, and people are walking past it all the time, there's exposure. If that guard's off, people are going to walk by it and it's unguarded, right? That's exposure to the hazardous condition. If you have a piece of equipment that's unguarded and no one walks through it, it's behind a light curtain, it is protected by location, it's not necessarily going to be exposed to, people aren't going to be exposed to the hazard. That's a consideration that we have to look at when we're trying to evaluate this determination, is how exposed were people to the potentially hazardous condition. We already talked about the type of injury or an illness. One, it's going to be a serious injury. It's going to be probably death or serious injury. That is what they're looking for when they're talking about a serious. It isn't just that though. It could be, what we would classify as a permanently disabling injury, whether it's acute or a chronic long-term kind of disability. That could also classify and go into the determination of making something a serious citation. So, what the language that we see from OSHA is impairment of the body, which part of the body is made functionally useless or substantially reduces efficiency on or off the job. So that is something that they're going to look at as well. So, if we have to have someone on restricted duty, that could be the type of injury that, gets you into this classification. They could be looking at things like that. And then lastly, we have knowledge of the hazardous condition. That's a big one, and knowledge is determined a lot of different ways. Dan mentioned earlier, when you're reviewing your injury logs or 300 logs, is that establishing a pattern that you should have knowledge? You should have that constructive knowledge. Here, with the exercise of reasonable diligence, or, is it something that it was totally unknown to you? Maybe it's a new piece of equipment. You were unaware of it. You had the appropriate training. You had the appropriate safety equipment for this. And, a condition developed, something that you weren't aware of, or maybe it's a new operation that you've acquired, new facility, and you weren't aware of that. And it wasn't reasonable that you would be aware of it just through the normal operation or normal diligence. Then, those are the kinds of questions that we're looking at in terms of employer knowledge. And also, who had that knowledge, right? Was that someone in management or safety that had the knowledge about, a potential hazardous condition? In which case, if it's management, it's going to be imputed to the company as a whole. If it's a safety personnel, you're probably going to be in a management position of some kind, or at least have the ability to push that through to management if you're aware of a hazard. And that again would possibly climb that change to, establishing knowledge of the hazardous condition by the company. That's a little bit different than if, You got kind of frontline workers who knew about something and never reported it, never told anyone. Obviously that brings in a lot of different questions about employee misconduct and training and things like that we would be exploring at that point in time. But knowledge is a pretty critical, and there's a lot of ways in which they can go through that. Yep, that's okay.
You referred to, said something, you were referring to you, the employer, or you an individual in the company about knowing about a hazard?
Well, it can be both, right? If you're a manager, your knowledge as an individual is imputed. The company is assumed to have known that as well, because you're an agent of the company, you're a supervisor and manager. So that's you can be the company, or it can be the individual.
100%. Okay.
Exactly. Yeah.
And you'll see in an OSHA inspection file, there's going to be the section where they cover employer knowledge. And there's going to be, statements attributed to management, personnel, safety and health personnel, perhaps, or looking at your logs, again, going back to the record keeping piece of it. They'll outline what the basis of employer knowledge is, but for purposes of imputing knowledge to the company, it'll be management and supervisors.
Yeah, it's usually an interesting exercise to read through those parts of the investigation file too, because you realize kind of what was paid attention to, what kind of comments, and especially if you're someone who's cited in there as making a comment, right, or making an admission. That's always an eye-opening exercise, because when you work through with somebody and you're walking through and you're saying, well, look, OSHA is making this determination because they believe, or they have said that you made this statement at this point in time. And it's often interesting because it will be a quote. It will be a quotation mark of what you said. Now, there probably wasn't a signed statement. Sometimes there is, probably wasn't. It might have not even been kind of in any kind of formal recorded interview or setting, but nonetheless, that's kind of more in when we're really getting into the contest process, when we're really getting into kind of going through and preparing for discovery and things like that, that you're going to start seeing those kinds of disconnects. But they very often rely upon statements, or their version of statements that were made by managers in terms of developing that. All right, so a little bit blocked, but you heard Dan talk about these before, but repeat violations are the next type of violation that we're going to talk about. And I think that this is an important one. I think we'll probably talk about this for a while. We got a few slides on it because it is a trend that we're seeing increase the use of repeat violations. They have kind of an elevated severity index, right? They are more severe because it is a repeat of a prior violation. This is obviously a little bit outdated because it's the language of the act itself, but as Dan mentioned, they've also got higher penalties, so up to 150 and change per issuance. Here it obviously says 70. That's no longer the case, but it is for an employer who repeatedly violates a requirement of Section 5, so the standards, any rule or order promulgated pursuant to this act, and may be assessed a civil penalty of not more than $70,000 for each violation. Obviously, that part at the end is outdated, but the rest of it is not. But that is really the extent to which we have a definition of a repeat violation in the OSHA Act itself. So when we have a situation where we don't get clear guidance from Congress when they're writing these kinds of rules and regulations and acts, we have to rely on the litigation and the court system. So in this case, we are going to look at a couple cases and what those kind of developed and brought down. And it's from the Occupational Safety and Health Review Commission. So that is what OSHRC means. You guys heard of OSHRC before? Yeah. Okay. So some people have. So this is an administrative body, also created under the OSHA Act, but separate from OSHA, that is independent and hears cases between employers and OSHA, right? It is meant for us to litigate citations before, and they offer guidance and create case law by which, we are held. we go through that process. That's where we would have our initial hearing if we were challenging a citation. We got that far with an administrative law judge or an ALJ. And then there's actually a commission, which is a group of commissioners, a panel, and they would hear cases on appeal. And from there, if you're going to appeal further, you're appealing into the federal court system. So you're now getting into the Federal Court of Appeals. So that is kind of a quick review of kind of the legal side of where we're at. And so why is that important? It's because if we don't have clear guidance from the agency or from Congress, we have to get guidance. That's how we have to litigate these things and why we litigate them, to get that kind of clarity. So repeat violations. This is the Occupational Safety and Health Act of 1970. By 1979, we are already having litigation on repeat violations. So that's fairly quick, especially since back in the 70s, we didn't certainly not have the agency that we have today in terms of how enforcement is issued and how it goes through that process. But in that case of Potlatch Corporation, the commission defined repeat as one citation for which OSHA previously cited the employer for a substantially similar condition. And in this case, the review commission had affirmed the prior citation. So it was determined that the fact that the violations occurred at different work sites did not necessarily mean anything to us, or nor the length of times between the two citations, right? That's what they're looking at. Yes. Yeah. So the question was brought up about the look back period for repeat violations. I think we'll talk about that more, but do you want to give a quick rundown of that, about why we say 5 years versus unlimited?
Yeah, so technically, it is unlimited, based on this,
And another case.
yeah, a couple different cases from the commission, but OSHA has a field operations manual that says for purposes of evaluating a repeat and whether to issue that characterization, we're only going to look at your enforcement history over the past 5 years. So that's where that 5-year look back period comes into play. We haven't seen OSHA in my 8.5 years of practice or so extend beyond that. It's not to say that they can't, but that's what's outlined in their field operations manual, and that's usually what they're sticking by.
Yeah. So essentially they've set some internal guide rails. But the commission has given them in their decisions the authority to go back farther if they want. They just haven't done that, and they haven't changed what's written in that field operation manuals to say unlimited look back. So, we have a hearing situation, often the case, the same employer, and we'll talk about that might not always be the case in the next couple of slides, and they received a prior citation for the same or a substantially similar condition or hazard. And then that prior citation became a final order of the commission. A citation becomes a final order of a commission when it's issued and you don't contest it and get it modified, or if you go through contest and you agree to settle it, that settled version will become the final order. And this goes back to what Dan said earlier, talking about serious citations and why that classification of serious to other than serious, it's important. But sometimes it's a bit of a red herring, right? It's they kind of blind you with that, when the real thing that you need to be concerned about is that underlying condition. Are you being cited for a standard that is very easy to repeat? Or are you having a description that you don't necessarily think identified a hazard or accurately identified a hazard, but you haven't sought change of that description of the violation? And then you have, a substantially similar hazard described in another facility or at the same facility in a period of time. The question is, was it serious? No, that's not the only question you ask. Now, it's more likely that OSHA is going to look at serious violations when determining, whether or not to issue repeats, but they can look at other than serious just as easily. So you want to be looking at what the citation was, what standard was it cited under, and then how is the hazard described in the citation itself? Has everyone in here seen an OSHA citation before? Yeah. Okay. So what do you have there? You have it's pretty bare bones, the actual citation itself, right? You have the cited standard that they say, or they allege that the company violated, and they put out what they think is the relevant text to that standard. And then there's a small description about what you guys actually did wrong in their opinion. And they're usually maybe a sentence or two, right? They're not novels, but that language right there is incredibly important to evaluate, to understand, and also to seek modification of for the purpose of repeat defense, right? So we want to, whenever we're looking at a citation, we're looking at enforcement, we're trying to look forward through the lens of what could possibly happen again, even in the face of our best efforts and best intentions, what could possibly happen again? We have to be mindful of that. The other part about repeats is generally they're the same corporate entity, right? That's usually what we see, but that's not necessarily the case. You can have some successor liability for past violations of the predecessor. But when you're looking there, there has to be some pretty strong connection to what was the operations under the previous employer. You know, if we're just doing an alter ego, maybe it's the same company, but we now have a different name, or we refinanced, or we went through bankruptcy, but everything's the exact same. Obviously, that's a pretty easy line to look at. You're going to look at the nature of the business, the jobs worked, who are the safety and health managers or the managers in general? Are those the same? Have they carried over? Where we kind of see it sometimes go and catch us by surprise a little bit is when we have, what we think is a clean break in either an acquisition or a sale or something along those lines, but they still try to connect the dots on that repeat. And those are the ones where we have to start looking at earnestly, what types of changes have taken place before that. Has there been substantial continuity from the organization that had committed the prior violations that are now final order, right? So, a lot of times the type of business might be the same, the facility operations might be the same, production processes, customer served, those might all be very similar, along with the jobs and working conditions. If we haven't changed anything, if it all is kind of just continuation, but now we have another facility under our control doing a specific task or doing something like maybe it's a new warehouse, they're going to look though at the types and job positions, how many employees were carried over. The big one though is going to be looking at continuation of management and the processes and the training and things like that. Have we taken the steps to take that prior company and turn it into, another one of our entities by, changing up their training? Maybe we put in new management persons, maybe we put in new safety persons. Those are going to be a pretty important evaluation in the process of determining, whether or not they think substantial continuity exists for a repeat. And, so in that case, we're talking about, Nick's company got a citation and then Dan's company bought me out and continued operations at the same facility, and they got a citation. They gave him a repeat for something that happened at my site. That's what we're talking about here. So that's kind of the analysis that we look through. And it happens a lot when we're doing acquisitions. That's usually when it comes into question for employers, when you're taking on somebody else's facility, or you buy them out, or you're adding an existing structure, an existing facility to our inventory. We do have to be careful there and, kind of look at that and, not just allow it to continue as normal, but go in and make sure that we're implementing our policies, our programs, our expectations on that, so that we can, be sure to draw that line in the sand. As we talked about, it's violations of the same standard or violations of a different standard under similar conditions. So it's really that condition that they're looking at is part of the most important elements. That similarity of the hazard is what the review commission has really looked at, along with similarity of conditions or methods of abatement. Meaning, how did we correct this? If we corrected it in the same way that we're going to correct another hazard, they've used that as kind of a basis for justifying repeats as well. Usually, though, it has to go back to, and they look most closely at similarity of the hazard and or standards, right? Those are the biggest one that we want to consider. So if it's again, it's not really a relevant argument to say that it was different work sites unless we're claiming different corporate entities. It's obviously something that we're going to argue and we're going to push back on, but for the purpose of kind of the repeat violation, substantially similar violations, they don't take that into consideration as much. So those are kind of some areas that we have to look at there. Now, OSHA has federal OSHA, and then there are the states that have their versions of OSHA where they don't have concurrent jurisdiction, but the state runs their own plan in that state. So why is that important in this discussion? Because state program citations cannot serve for the basis of a repeat in a federal OSHA state. So if we have a violation that takes place in, Virginia, that can't be used to give the basis for a repeat in Pennsylvania, right? They're distinct. Similarly, it goes the other way as too. Federal OSHA citations cannot serve as the basis for repeats. Sometimes it's not common, but we see them look back at that. And if they are substantially similar, if they are similar enough, they'll try and use that as a justification of evidence or knowledge for establishing a willful citation, a more serious citation. But for the purpose of repeat, that distinction between state plans and the federal plans is important. So I think Dan was saying you guys got operations in a few state plan states.
Yeah, I think as you can see on the map here, this is broken up a little bit. There's a couple state plans that just operate the state OSHA program for government workers, but Virginia and Maryland are probably the two state plans that you all are operating in. I don't know, do you have any stores? Oh, you have North Carolina? Okay, so North Carolina as well, Vermont. Do you have any in Vermont? No, okay. So three state plans that you're operating in. Like Nick said, those citations there can't be used as the basis for a repeat anywhere else except within that state. But if you have something in New York and within 5 years you have a substantially similar condition that's cited for, say, in Pennsylvania, Massachusetts, that can be a repeat, even if it's issued in two separate states, two different area offices. That's how that works. So we talked about the kind of the look back. We had a question on that one already. So initially, earlier versions of the field operations manual, the FOM, that set a 3-year look back for repeat. Under the Obama administration, that was expanded to 5 years. In the Trump administration, they kind of rolled that back a little bit. They didn't necessarily formally do it, but they just didn't kind of push forward as hard in that. But there was a case that held that OSHA is not bound by a stated look back. And that gives them the unlimited one that we've talked about. So a little bit of a distinction, a disagreement. It's probably not going to be too long before we see an update to the field operations manual or an attempt to do so to memorialize that. But right now, the commission has kind of spoken on that front, and we see 5. That's the normal one. That's what we typically see, but they do have authority to go back beyond. We would obviously check them, but since they're going in kind of against the grain of their field operations manual, but the courts have supported that. So a willful violation, the last one we're going to talk about right now, is willful, and it's for an employer who willfully violates sections of the act, may be assessed a penalty of not more than 70,000. Again, that's not up to date. That's from the language of the act. It's now 150,000 again per issuance. But it is really, these are for the more egregious ones, right? So it's 2 ways to show willfulness. It's intentional, knowing, voluntary, or disregard, or plain indifference to employee safety. Now, we talked there on the last couple slides, we could see it's not common, but OSHA try and use state plan violations in order to kind of justify if there's similar enough willful designations. But willful designations are almost certainly going to come down to knowledge, how open and obvious it was, how much we knew about it, did we just ignore it? Those are going to be what they're looking at. So these are highly dependent and really dictated by the course of usually manager interviews, right? If we have admissions that admit that there was knowledge or admit that there was intentional disregard or that we just chose to go a different direction,
without substantial justification, that's where we're going to get to a willfulness. They're not nearly as common as the other types of violations, but they are one that we want to be aware of. So how does OSHA go and try and prove that there was intentional disregard? Well, one way is that there was awareness of the OSHA Act or the applicable standard, right? We knew what OSHA said we should or shouldn't be doing. We knew of the condition or practice that went against that in the workplace, and we failed to abate the condition, right? So we knew that there was a condition, we knew it was in violation of the act, and we didn't correct it. Okay. The other one is we did not know about the OSHA standards, but we knew that there was some kind of legal requirements, whether it's state or local law or something that put an emphasis on us to act a certain way. And we were aware of the condition or practice that went against that. So you don't always have to know that you were in direct violation of the act, right? So the last one is there was awareness of a legal requirement, but a substitution of judgment for requirements of the standard. So we knew it, but we made a decision not to follow it or to go against it. That is how OSHA is going to, those are different areas, kind of scenarios we're going to look at when looking to prove intentional disregard for the purpose of issuing a willful violation. The other one is plain indifference. And this is either where the employee is not aware of it, but they knew the condition or practice reflects a serious hazard and makes no effort to abate the condition, right? So there's, things that we don't even really contemplate, right? This sounds just, we knew of a hazard and we did nothing to correct it. That's not how we operate. That's not how we look after our people. But nonetheless, this is what they're going to be looking at in order to sustain issuing a willful. And then management's aware of an applicable requirement and made little or no effort to communicate it to lower level supervisors and employees. So you just didn't roll out the knowledge. You didn't communicate that otherwise. You didn't get that information out to the people that needed it in order to enact it or to work safely around it. And if we're going through these kinds of exercises where these are taking place, that's when plain indifference is going to come. So it's about follow through a lot of the times, right? If we see something, we have to follow up on it. If we become aware of something, we need to pass that information on to the persons who can act upon it or help implement it or help put in protective measures. And we need to follow up on that as well. This is really, in my opinion, the plain indifference is just kind of the, okay, well, that's great. Keep going and keep doing what you're doing, right? That's what they're looking at here. What does OSHA look at when they're trying to determine this? They're going to look at a lot of things. I think probably, as I talked about before, the bottom one is the most common way that they are going to get to willfulness. Statements about prioritizing profitability over safety, or if they're getting that from an employee who feels that way and we have to then defend that allegation, a lot of times those are, the most common way that we're going to take a normal inspection, maybe don't see it going towards willful and it goes there quickly, or we are at least put in the position that we're defending that, is allegations of profitability over safety, right? Production over safety. Yes, ma'am.
Like, let's say something happens, you find out it's the president, and you're working on a plan to roll out to all the stores. How fast is OSHA expect you to get it out?
Yeah, so the question is, I'll just repeat it for this. How quickly do you have to disseminate information once you learn of, a potential hazard? I don't think there's not a day, 5, 10, 15, 20 month time frame that we can give you. It depends on the type of the hazard and the efforts that you're putting into it. So, if it is a quick fix, maybe it's something you can roll out very quickly. It's cheap, effective, you can get it in place and, you can just get that out there. Obviously, you'd be wanting to do something quickly on that. If it's more of a situation where now we're going to have to do capital improvement projects, we're going to have to engineer a solution. What we want to do in that case, though, we still want to obviously act quickly, but to document, one, that we're taking appropriate steps, and two, are we developing interim protective measures, right? Are we developing something that in the meantime, while we're doing this bigger fix, protects them from that hazard that we identified? And so, it really depends on what we're going to do and what we're going to be. Obviously, we have to move quickly, but, that can be communicating that there's a new procedure, like do not do this task in this way and train everybody on it. and then you engineer that task out, or you develop a new tool or process for completing it. Those are kinds of the different steps. So it depends on the type of thing that we're communicating. There isn't a deadline. Obviously, if we identify something and then there's an injury, it could be 10 minutes later and OSHA is going to say you didn't move quickly enough, probably, right? We're going to be defending that. Or, it could be a year later and nothing's happened because we've worked around it or something along those lines. But it's about, though, creating kind of that plan and that approach, and as quickly as possible, determining if there's an immediate action that can be taken to provide protection while we figure out our long term.
Just to answer that, based on experience here, a lot of things that we have a plan that's in the scenario, we submitted here to the side. However, we wanted to look at them prepared and updated and get it back to the other one, that case, we had a plan, right, we're marching toward our plan. Once it came in, and we were cited, and there were serious citations, but we did not have the willful, we didn't have the plan. We probably could have, right? It was up to their discretion.
Yeah. So OSHA does have a self-audit policy where they encourage you as employers to do audits and find potential gaps, things that need improvement. And that policy that they have says they won't use your self-audit as the basis of willfulness. So it's very rare that you'd see that, taking something that you've identified in an audit and using that as the sole basis of knowledge.
Yeah. Well, I mean, but there's other elements as well. Yes. Go
But
ahead.
it also fall in, let's say you got a program that you need to get out. And I don't think it's so much profitability, but we had like a 4-year plan to do 110 stores. And if something happened at one of those stores, let's say it was in the last year, it was due to be done in the last year, but something occurred before that. And they still come at us, and well, we had a plan to get it all done, but it took, whether it was budgeting or time, it took 4 years.
Yeah, I mean, so the question is, what if it may not be profitability or production over safety, but we have a plan in place, and that's a multi-year plan to roll out some kind of program, and we just haven't gotten there yet. That's kind of the question?
We started at year 1. But
Yeah.
It took 4 years to get through that many buildings.
I mean, and there was an incident, one that you hadn't got to yet. So, I mean, I think the question here, again, this isn't, it's not an absolute, right? This is going to come down to how we're communicating this to OSHA and how we're providing that information. I think it is likely going to be, if all let's assume all stores are created equal, right? All stores have the same hazard, the same risk, subject to this particular item. So, I think it comes back again to the same thing. One, do we think that this is a high profile item? Likelihood of injury is relatively high. The severity of the injury could be serious, or the occupational illness could be serious. And we're taking 4 years, is that a reasonable approach there? I think depends on the nature of the hazard, and also what have we done in the interim to kind of offer some preliminary protections against it. So, to say that we did, again, I'm gonna, you also take Lee's example of a guarding. So maybe we have the same machine in every store, and we're taking 4 years to guard it. I think you're gonna have to probably figure out a pretty good reason why you're taking 4 years to guard this machine in all these different locations, unless you're taking some other preliminary step to protect against people at the unguarded locations. So you're gonna have to justify it. It really depends on the type of program or thing that you're trying to roll out. You want to add anything there?
Yeah. If it's the high gravity hazards that OSHA is going to be looking at to prioritize, and it's going to take you 4 or 5 years to make those fixes, that's probably not going to be viewed favorably by the agency, right?
Yeah.
We have a plan in place and we have action items to fix these issues. That goes a long way, and having those discussions with the agency, right? A show of good faith and bridging kind of the communications demonstrating you have good safety culture, you're auditing, you have identified potential hazards, you're in the process of fixing them. That can help in settlement negotiations. But yeah, if it's kind of a 4-year plan of high gravity hazard, you're probably going to be cited for it if something happens. Certainly, if there's an incident related to that hazard that you've identified,
Yeah.
the likelihood of citation will be high.
And you're gonna be graded on whether or not you took any steps in the interim to protect against it. So, I mean, that is going to be a big one. Yeah.
For serious, I think, or
What do you think there, Dan?
Yeah. So the question was, does OSHA really just characterize willfulness for kind of like greater hazards, or could it be something like record keeping? It could be something like record keeping. Is that likely? No. It's really cases that are pretty egregious, right? Where there's that plain indifference, you're completely ignoring mostly safety or health hazards. If it comes down to a paperwork issue, likely not going to see a willful citation.
You could see in the record keeping, because usually when you're having record keeping, you're talking about there's probably more than one violation there. And Dan's going to talk later about the instance by instance policy. But I mean, you can probably be looking at some pretty heavy enforcement without going willful, just in terms of repeat and a number of different repeats for each instance of it. So they can get you, there's a pretty punitive effect out there without going to willful because of the other elements of willfulness that have to go into it. But, they're going to be looking at, again, previous citations under the standard, lack of programs dealing with the cited safety issues, statements from employees, statements from managers going through the investigations and the interviews. And we'll talk about this a bit later with the management of interviews or the investigation process. But there's, it's not a checkbox where every one of these items has to be checked, right? It can be a pretty egregious in one of them, and that's going to move the needle to willfulness. Now, it's not common. Again, we don't see these all the time, but they are out there. And most of it, though, comes back to, employer knowledge, and you knew of a condition and you didn't do enough, or you didn't do anything to correct it or protect against it. As we talked about earlier, with each one of these, you're going to get an assigned abatement time frame. Failure to abate. Orders can take place when you don't do that, right? You have made, you continued operations, it's not abated, the abatement date's come and passed, and you've not complied with the terms, whether it's from the terms of actually the citation itself and the time frame that was attached to it when you get that in the mail, or when it was issued, you have a settlement agreement where we're agreeing to abatement terms. So usually, as long as we're kind of talking with OSHA and talking through it and making progress on it, we can avoid these kinds of discussions and these kinds of issuances. But in situations where someone's just not doing anything, they can get a failure to abate. Excuse me.
And
Go ahead.
one thing that I want to emphasize here, if you contest the citation, abatement is stayed during that period. With that being said, right, if you do recognize that there may be some type of hazard there, it's probably in your best interest to go ahead and start making those changes, notwithstanding your dispute and contest of the alleged violation. Also, the abatement date is important, because if you don't abate it, you don't submit that abatement verification to OSHA, they're going to give you time. They're going to follow up with you and be like, hey, abatement's due. Demonstrate what you did, what the steps you took to abate the hazard. If you ignore them, if you don't do it, and this is really when you get kind of recalcitrant in responding to OSHA, you can get these failure to abate citations where it's per day penalties for failing to abate it. It's maximum, I think, up to 30 days. But if you're looking at 30 days and $15,000 a day, that could be a pretty penny, right? We don't run into these issues ever, really, but it's something that you can't ignore.
Yeah, it's one of those things that if you're working with them and you're taking action and you're pushing things forward, they're usually going to avoid getting to this point. But if you're just ignoring them or not taking any action, then we start talking about these. we'll move quickly through these because I think I'm already behind on our time frame. So, but there are some criminal provisions within the OSHA Act itself. They may refer cases to the Department of Justice. If an employer received a willful violation and there is some evidence that willful violation resulted in the employee fatality, right? So not it is directly related, but there is some evidence they are connected. There's obviously, these are not very common. They have to be kind of the most egregious of the egregious situations, but it is a possibility there. So the employer can be convicted under criminal charges from the OSHA Act. The Department of Justice is involved. There can be additional penalties and for the corporation, for individuals, and even imprisonment. If there is a willful violation that is the direct cause determined by OSHA of a worker fatality, it will be referred for a criminal charge. That can include a misdemeanor charge up to 6 months imprisonment, and then up to additional fine of $250,000 for the individual and $500,000 for the organization. So, those again, these aren't normal circumstances, right? This is not the usual investigation. This is not the usual injury, the usual fatality case even, but it is a provision that is out there and that has to be recognized, and we need to be aware of it.
Yeah, and this isn't intended to scare you. This is just the holistic overview of OSHA's enforcement authority, right? There's a criminal component to it. We rarely ever see this. If you deal with environmental issues, that's where you're going to see the most kind of overlap of workplace safety and environmental issues, where the criminal actions come into place, right? The EPA has significantly more penal outcomes, so to speak. So you'll see more of those types of cases in the environmental side, where it intersects with OSHA and workplace safety. A lot of things with construction, manufacturing, those types of cases.
Yeah, but I mean, I think the big one is though, don't lie to the regulators in the midst of an investigation. Don't falsify documents. Don't create new documents after the fact. Some of those things that we just probably can't even wrap our head around someone doing. That's usually where we get into most situations where we're now climbing the ladder and this becomes a possibility or even a consideration. You knew of it, you're trying to hide it, you're trying to get around it. Probably the outcome of whatever transpires for a honest failure to do a certain thing is going to be less than the intentional act of trying to cover it up. We are dealing with essentially, federal investigators, right? And they like to remind you of that when you're talking to them, like, you can't lie to me. I'm a federal agent. It's true, for the purposes of 18 USC and what goes on there. So you want to just move quickly through that and then take a break after this slide? Yeah. Okay. All right. There's a few in here. This is just kind of some general enforcement data, and then I think we'll let everyone take a quick break, but just looking kind of at the number of inspections, we are slowly seeing the numbers tick back up. The first set of blue lines, 2010 through 2016, that was the Obama administration, and then the red, when we start seeing a decrease, is largely during the Trump administration. Now, we didn't see as much of a drop off as we thought during that administration with the deregulatory agenda that was touted. And that was largely in part because they failed to get political leadership appointed at OSHA. Actually went 4 years without having a confirmed assistant secretary of OSHA. So with this administration, obviously that was a emphasis at the very beginning. We heard a lot about it even in the campaigns about getting people in that position. And so we're starting to see those numbers tick back up. This has data through 22, 23, the numbers are much higher already. So the inspections are going to continue to go back up. We have about 1,000 compliance officers, a COSHA, compliance safety and health officers. They're relatively new. We're seeing a lot of turnover, a lot of education having to be provided by employers during investigations and during inspections, which is not always a fun place to be, depending on the attitude. So you do have an opportunity, though, if you're dealing with a young compliance officer, to help them see that not all employers are bad and that maybe we can help give some education there. But we are also seeing part and parcel for this increases inspection is the national and local emphasis programs that are being kind of rolled out. And this is a cross section of a lot of different industries that are going to be covered, but there's a combustible dust national emphasis program, fall hazards, amputation. So that has to go with lockout, tagout, and machine guarding. Dan mentioned, and we'll talk more about heat illness, lead, silica, heavy metals. There's also one that is going to be probably applicable to you guys in terms of the regional and local emphasis programs on food manufacturing and warehousing, forklifts, and those items. And I know I won't kind of dig into those too much because you got slides on them later on, but this is a big reason why we're having these increased inspections, right? There's a lot of emphasis programs. There's a lot of reasons and ways that OSHA is getting into different work sites, whether if it's by complaints or by just flagging that you are in the SIC codes that apply to this emphasis program, and therefore we are going to visit. So that is driving a lot of the trends upward in the enforcement.
Yeah, and you see that 50% of the inspections in fiscal year 2022 were characterized under some type of emphasis program. So if they come out for a complaint, perhaps, and it's related to one of these issues that's outlined in the emphasis program, they're going to characterize it under the emphasis program, right? So they have broad inspection authority. And you might see a couple different emphasis programs characterized in OSHA's establishment search page. It could be warehousing and distribution centers and forklifts, right? They're going to look at everything. And we'll touch on those in a couple slides here, but this is kind of the increase in the types of emphasis programs that we've seen over the past couple of years, and certainly a couple that are applicable to your industry.
Yeah. The other thing we also see though is sometimes when the compliance officers are on site for one area, if they see something that might tick the box on an emphasis program, they'll open up another inspection into that. So you might start off with a pointed health inspection, and then all of a sudden you're getting a warehousing or a forklift or something like that.
Yeah, all they have to see is a forklift drive by, basically, and that can be the basis for expanding the scope of an inspection. So it is tough in that regard. You can't shut down your operations, right? But just be cognizant that they can expand the scope of the inspection just based on plain view.
Yeah, and we'll talk about that when we get into managing how, when we're doing an on-site investigation, we want to be tailored in the routes we take to specific areas and make sure that we're just going to that area. We don't need to do the compliance officer a favor and show them the entire facility when they want to look at a specific machine or specific process. Just in terms of the penalties, we saw a big jump in penalties overall in 2016. There was an act called the Inflation Adjustment Act, which brought penalties back kind of normal inflation from when they were originally put out, the historical values. So we saw a significant jump in that year, obviously. And then every year since in January, the penalties for OSHA go up depending on inflation. So now moving forward, you get a new penalty structure every year, but it's due to that Inflation Adjustment Act, which we saw go into effect in 16. And so when they're dealing with penalties from the 70s, now all of a sudden you have inflation adjustment. That's how we get from a maximum penalty of 100 or 70,000 on a willful to 124 in 1 year. It was a big jump there, but now we're increasing, and we're already up, less than 10 years later to 156,000 and change as a maximum. Those I think are probably few and far between. You're probably looking more so at the list other than serious and serious as a normal kind of cases. But the repeats also fall into that higher one as well, which is why we've mentioned that they're, important to keep monitoring because they are a punitive effect in terms of what they can do financially. And then the bottom one is obviously the failure abate that we talked about in terms of the maximum per day penalties. We've talked a good bit about repeat. There is a reason for that. And that is because we are starting to see repeats increase in how often they're being issued, right? We can see here, if we look at the repeat violations from 2002 to 2022, so 20 years, they have more than doubled in the percentage of the violations that OSHA has issued. So it was 2.4% of OSHA citations, which is repeat. Now it's up to 5.9. So using that more often, using it, and that has to do with the look back period being expanded, the use of the targeting that they have. So follow-up inspections, selecting past violators for additional inspections, having these kinds of emphasis programs that kind of bring you back under the microscope when they just see that you have a particular function at your facility. And then also, treating facilities with the same corporate entity as a single workplace. Those are some of the areas that we have seen which have drawn this percentage up, and why we're seeing that as being a more common element that they have cited. The serious. Yeah, there's a significant drop in the serious violations.
Yeah, we did see a drop in the number of serious violations. And that's because we did have, especially as we get into the later stages there, transition to a Republican administration. Enforcement is a little less severe, I guess you could say. There's more emphasis on compliance assistance. That doesn't mean that they're not going to stop enforcement and issuing citations, but you tend to see less during a Republican administration. Notwithstanding that, we saw a higher percentage of repeat violations. The characterization with that comes higher penalties. So that's kind of the data that we've seen over the past decade or so.
Yeah, but you're right though. That is it's a 30,000 citation drop off per annual. I'm sorry, what? Yeah, and it hasn't recovered yet. We haven't seen them get back because there's such a gap really to get back to. And that also falls under, right, the pandemic. That drop is partially pandemic induced when they really stopped doing a lot of inspections, and enforcement dropped significantly because they just weren't coming out to places unless they absolutely had to. So that's another reason why we see a 2020, 21, 22 drop. And additionally, they really lost a lot of enforcement personnel in that time frame. A lot of people just opted to retire, and during then, and so their numbers of compliance personnel, they're hiring a lot, right? But their numbers are still low. They're still lower than they want them to be, and that has driven down the number of inspections that they can do over the years as well. So that drop is partially, one, it's a trend that was going down for sure from early 2000s, but it was also partially having to do with the number of inspectors available and the pandemic. Another one though on that as well is to consider is the penalty increase, right? To get the punitive effect they want sometimes on a company, they want to have the penalties are meant to be the punitive. You have to pay these penalties. That's going to make you do it differently in the future. And when you can have higher penalties with a single issuance, maybe they're not trying to issue as many individual penalties. But that kind of comes back to in terms of the penalty and things like that. What was at one time considered a significant case, which was over $100,000 in penalties. They have, for their own internal reporting policies, OSHA has changed what they consider a significant case from 100,000 to 250,000. But for tracking purposes, for analysis, we continue to consider it 100,000 because that lets us look at it from across the board. And so you can see though in 2022 was really, kind of a 12-year high in the number of cases that were issued with a total penalty over 100,000. So the significant action. So that increased quite a bit. Again, we see, 2020 was a low point other than 2013, but we, have seen those climb up, and we again expect that this year will probably be an even higher number than that. I think though, oh yeah, I'm sorry, the press releases. So I think this is the last one, and we'll take a break and turn it over to Dan. But another thing that we have seen with OSHA, and this is largely carried over, but not to the same extent between administrations, is what we somewhat refer to as regulation by shaming. And it's the use of press releases. So we see it fairly often, quite a bit in this administration, quite a bit. We can see, 23 per month. But these are press releases that are issued when OSHA issues citations. And they go out and they say that, this corporation had, received violations for this, talks about the contents of the citation, includes a copy of the citation, link to it so that people can get copies of it and go and read it. And they draw a lot of press, right? They post them on their website, they send them out on their email blast to their listserv. They put them out usually the same day that you get a copy of your citations. And if not the same day, within a couple of days. I recently had a compliance officer who called a client and said we wanted to drop off the citations, and we said, okay, well, we'll meet with you at the end of the week. And the compliance officer said, no, it's got to be today, and showed up like 20 minutes later at the work site to hand the packet. And it was because they had a press release prepared and ready to go out. They will generally just paint the company in a bad light. They don't get retracted, they don't get corrected. OSHA doesn't like to negotiate about releasing them, although we try. So it's important to kind of measure, and this is again why when you go through the investigation process, really advocating as you go, because the contents of what they collect during that, however skewed that is, if they don't have the whole story, that whole story isn't going to come out in that press release. And then that's going to look just optically bad. It paints us in a light that it may not be justified, or it may not accurately characterize what the enforcement was or the issue was. And again, it's not going to be retracted, right? We can try and get them to release maybe one around settlement if we push for it, but a lot of times the damage is done at that point, just from a PR standpoint for us as an employer and a community member. But I think you want to take a break?
Yeah, we can take a break now, and then we'll come back to some of the new enforcement tools and then jump into the record keeping and reporting section.
Okay, you guys want to take? Sounds good.
All right, we're gonna go ahead and get started again. And now we're gonna transition to some of OSHA's new enforcement tools, starting with the severe violator enforcement program. And over the past couple months, there was, or I should say, I think it was the past 6 months or so, there's been an update to OSHA Severe Violator Enforcement Program. This is a program you don't want to find yourself in. The criteria for getting in is what you see on the screen here. It was any egregious enforcement action, one or more willful repeat or failure to abate citations related to a fatality or catastrophe. And the big one that we're concerned with is 2 or more willful repeat or failure to abate citations related to high emphasis hazards. And those high emphasis hazards are what you see on the bottom of the screen here: falls, silica amputations, oil and gas, excavations. Not so many of these are really applicable to your industry, maybe falls, right? But there was this change, and you see the one under the process safety standard, 1% of cases qualified in SFAP from there. And we'll talk about some of the consequences of falling into that program. But these changes were updated back in, or I should say the program was updated back in September 2022. The big change was replacing that high emphasis hazard criterion with 2 or more high gravity, willful repeat or failure to abate violations. Basically, what that means is it eliminated those high emphasis hazards. It can be any violation of any standard related to any hazard, as long as it's characterized as high gravity. And it is a willful repeat or failure to abate violation. What that means is, long and short, there's going to be more employers falling into the SFAP criterion. There would have been 100 or more cases last year alone that would have qualified into this. So the reasons that we want to go over this really quickly is if you find yourself in a case where you have 2 or more willful or repeat citations that are high gravity, and you fall into SVEP, it's really important. You're going to be contesting that citation probably, because you don't want to find yourself in this program, because these are the consequences, what you see on the screen here. Unlimited follow-up and sister facility inspections nationwide, meaning they can show up at any one of your facilities, be qualifying to SVEP, do the wall-to-wall inspection. Enhanced settlement agreements that are going to require third-party audits, maybe corporate-wide. As Nick mentioned, there's a lot of that public shaming with the press releases. See a lot of those SVEP cases end up on OSHA's website, right? Harm to the company's reputation, business prospects, employee relations and retention issues. And it can be used by unions or plaintiffs' attorneys, right? For union campaign and bargaining. And also if you're involved in any tort cases, things like that. So you are in the SVEP program until you complete, I can't remember the exact number of inspections without a violation. But once you're on it, right, it's very hard to get off, because basically I think it's, you know, if OSHA opens an inspection, the odds of you getting a citation are somewhere in like the high 80s percentage wise. So it's pretty tough to go. It could be. Yeah. It's very difficult. Yeah. That's why if you find yourself with a set of citations where you are put on the SVEP list, you are fighting that tooth and nail so you don't end up on that list. No.
These are the dollars to use, the ones we need about a lot, right? Sam's on that list.
The list, I believe it is publicly available. Those companies that you mentioned, they fight tooth and nail to make sure that they're not on that list. So with that come.
Section about the repeat, you know, the statewide,
Uh-huh.
So it's only certain states that Virginia and Maryland would not be able to jump out of their state to New York.
To issue a repeat. New York cannot use a citation, say it was a serious citation in Virginia, as the basis for issuing a repeat in New York,
Okay.
right? And vice versa.
But Virginia, could Maryland?
No.
No,
In the state plans, they can only issue a repeat citation based on a citation issued in their state.
so when you're looking at it, when it's federal OSHA, look at the entire country, that's one organization, right? When you're dealing with the state plan, they run that state, that's their wall, the walls are up around the border of that state.
Mhm.
The walls are up around the border of every state where it's not a state.
So what happened to Virginia State? Because
I mean, they do say Virginia's
But-
lower, but.
Yeah,
they can't come to New York if there was a finding that.
no. So
They
that,
can't use it,
yeah, we're talking about, for the severe violator enforcement program, we're having a conversation for those on the computer here about kind of the borders of the SVEP program, right? So if you qualify into the Fed OSHA SVEP list, the unlimited follow-up and sister inspections are going to be at any location in a Fed OSHA jurisdiction. Now, the state plans have their own SVEP programs that have to be substantially similar to Fed OSHA's. But if you're in a state plan SVEP program, you're only going to be getting those follow-up inspections in that state.
That's what I was trying to say.
You don't want to be on that list, period, though. So we're not going to get on that list. We're not going to get on that list, but wanted to flag it for you. If you get a citation package with 2 or more willful repeat failure to abate citations related to those high gravity hazards, you want to really take care of those. All right. Instance by instance citations, we referenced this earlier. This is a new enforcement tool that OSHA's rolled out. So historically, this was really, you know, OSHA's way of penalizing really egregious cases and harming employers that kind of really had clear bad faith in safety and health policies, right? It was really limited. You didn't see this a lot. It was limited to those employers, right, that, like I said, clear bad faith, just recalcitrant in their safety and health program, an extensive history of violations, really high injury and illness rates, or something that was really bad and willful that resulted in fatality or catastrophe, right? So willful plus was that standard. They just changed this in January. It replaces that historical willful plus threshold with really a much lower bar. So now serious and even other than serious violations can be issued per instance as long as they are high gravity and they're related to a high emphasis hazard. There's also one additional set of criterion, right? It is limited to standards that set individualized duties. So you see on the screen here an example of one of those standards that sets an individualized duty, right? A respirator shall be provided to each employee. So if you have a respiratory protection program, or you should, right? And you fail to provide a respirator to 20 employees that should have been in that program, if it comes to, be the high gravity type of violation, you could be looking at 20 citations, a penalty associated with each of them. So this is really new enforcement tool that OSHA is using. We've seen them use it in some cases that we're handling ourselves. And that's really kind of the way that OSHA is increasing their enforcement authority, right? By being able to issue more citations for basically the same type of hazard, the same type of violation, and increase the number of penalties. So that's why we're saying 2023, 2024, those graphs that we were looking at, they're going up. So what are those high emphasis hazards that we're talking about? It's going to be these 7 bullets that you see on screen here: falls from heights, machine guarding, lockout, tag out, respiratory protection, permit required confined space, trenching, excavation, and injury and illness record keeping citations involving high gravity hazards, right? Those high gravity hazards, greater probability, greater severity. That's what we talk about with high gravity violations. So here is the factors that OSHA is going to be looking at in evaluating whether to issue an instance by instance citation. And this is all outlined in the enforcement guidance that we have issued by the agency themselves. The proposed citations are related to fatality or catastrophe. The employer has received any willful repeat or failure to abate violation in the past 5 years. The classification is current. Employer fails to report a fatality, inpatient hospitalization, or amputation. So the reporting piece that we're covering. And finally, record keeping. Record keeping violations can be instance by instance. Again, they could be an other than serious violation, depending on the number of record keeping violations that may be found, right? A lot of times when you see an OSHA citation package, it might be one citation, but grouped, right? With instance or item 1, item 2, item 3, but it's citation 1, item 1, citation 1, item 2. So those are grouped violations. In the instance by instance citations now, it's just going to be violation 1, item 1, violation 2, item 1, violation 3, item 1, separate penalties for each. But it could be for the same type of violation. But if it's that individualized standard, right, that we're looking at here, and there's a variety of these in OSHA's book, right? But you see if there's that individualized standard and you're violating it applicable to several items, several employees, that's where you might find these types of increased enforcement. Yeah. If you're late in reporting, so if you have multiple reports that are deemed to be late, right, and they find out about these, then this is going to be pretty rare, probably, right? But if they have multiple late reports within that 6-month statute of limitations that they find out about, it could be an instance by instance citation. Yeah. So the next piece that we're going to touch on is the Falls National Emphasis Program. This is also a new enforcement program as of May 2023. It's applicable to all industries, and all the agency has to do is basically walk in and see someone working from heights, and that's going to trigger the NEP. It's really broad. State plans are required to adopt this, so you're going to find this in Virginia and Maryland as well. There's no expiration date on it. The inspection itself is going to be limited to inspecting falls and fall hazards, right? So again, evaluating the exposure to fall hazards, but like we've mentioned before, plain view authority, if OSHA sees a different type of potential hazard, the forklift, right? They can expand that to a forklift emphasis program inspection as well. So there's certain industries based on NAICS code that are targeted for these types of inspections, but it is applicable to all industries in the sense that if OSHA sees it, they're going to inspect it. And that's an emphasis for them moving forward. So if you have folks working from heights, perhaps in the distribution centers or, you know, from lifts in the stores, wherever it may be, and OSHA is inspecting and they see someone in there, see someone up there, they may be asking to look at fall protection program, equipment, harnesses, whatever it may be.
As well as stuff.
Construction is one of the targeted NAICS codes. Yes.
So it's safe to say if an inspector was in a store and saw someone on a lift and the chain wasn't up, right? Yeah, we trigger. Is that triggers fall or it trigger? That's a decision. So it's, yeah.
It could be both. And that was a question about whether there was a chain that wasn't attached to a scissor lift, perhaps, right? Could that trigger the fall NEP inspection? Yes, it can. And could it trigger a scaffolding emphasis program inspection? Yeah, certainly it can be both.
What about the back nut area of the receiving, it has the chain that goes across the over 14. Should be over 14. Should it is over 14. More than the chain. Yeah, it's still ain't go back there and something. Things don't cut too much.
All right. So now we're gonna look at the most recent NEP that's really applicable to your industry and your workplaces, right? And that's the new warehouses and high injury rate retail NEP. This is dating back to July 2023 when this rolled out. So over the last decade or so, warehouses and distribution centers, there's been a tremendous growth, right? Throughout the entire country, it tripled the number of employees in that industry. And with that growth, of course, injury and illnesses go up as well. And OSHA is collecting that data through the e-record keeping rule. BLS has collected that data, right? There's the intersection there with OSHA and the Bureau of Labor Statistics. They get that data, they're reviewing it, using all that data for enforcement targeting purposes. So this is what we have as an outgrowth of all that data that's been collected, right? And it's really tailored to address significant hazards in these workplaces. Like most emphasis programs, it's based on NAICS codes. So warehouse and distribution centers, of course, are included in that. Grocery stores, those are also identified in the NAICS codes list. It's an appendix in the emphasis program itself. So when we're talking about the scope of one of these inspections, it's a comprehensive safety inspection. What that means is it's wall to wall. You can't limit the scope of the inspection in any way, right? If you have an accident in your workplace, typically you limit the scope of the inspection to that accident. You bring them to, you bring the inspector to the location where the accident occurred, whatever potential hazards were associated with it, you walk them out. But the scope of an NEP inspection, they can walk basically wherever, look into all your programs generally, right? The high injury rate retail workplaces, those are going to be partial scope inspections limited to storage and loading areas, but those again can be expanded based on plain view, and given the cross section of all these different emphasis programs, the likelihood of there being some other emphasis program applicable is pretty high, right? But the four bullets at the bottom of the screen are really the big hazards that OSHA is looking at through this national emphasis program. powered industrial trucks, right? Forklifts and material handling and storage, walking working surfaces, so slip, trip, and fall hazards. Egress safety, that's a big one. We've seen a big uptick in these issues. So blocked aisles, fire safety, and then heat illness and ergonomics. So this is just for informational purposes, some of the NAICS codes that are covered on both the warehouse DC side and then the high injury rate retailers. You see supermarkets and grocery stores on that high injury rate retailers. And then of course, warehousing and storage on those warehouse DC sides. Those are the comprehensive wall-to-wall inspections. The high injury rate is the partial scope inspection. All right, and with that, state plans, they are required to adopt this emphasis program within 6 months. So it was by mid-September 2023. They had to submit a notice of intent to Fed OSHA to adopt it. So we're going to see those rolled out in state plans as well, Virginia and Maryland. So here's just a little bullet item of kind of steps you all can take to help protect yourselves in the event that one of these does occur, right? And it is likely based on the data, the enforcement targeting purposes, they're generating lists to go out and find these types of workplaces that have these hazards. So inevitably you will have an NEP inspection for warehousing and distribution centers. And you may be doing some of these already, right? Auditing your DCs and stores for hazard compliance issues that OSHA is going to inspect during these inspections, powered industrial trucks, walking working surfaces for slip, trip, and fall hazards, heat illness. Make sure you're doing your training and the documentation is up to date, maintained. That makes it really easy to provide that information to the inspector and they can check the box, right? Review and enhance any of your written programs that you might need that are related especially to those hazards, right? Forklifts, slip, trip, and falls, heat illness, that's a big one. We're going to talk about that in the rulemaking that's underway right now, but that's a big enforcement priority for OSHA right now. They have their own heat illness national emphasis program on that. So again, another overlap of programs where it seems like you're getting beat up, right? But it's just the same hazards covered in a different way in a program. All right. And then benchmark retailers' experience in these NEP inspections, compile a list of documents OSHA is requesting. So things that you know are going to happen, right? The types of documents that OSHA is going to be looking for and questions that they're going to be asking during the interviews. So giving some refresher to management about, hey, these inspections are coming. Here's how to handle them. Make sure we have this documentation in place and the policies are up to date. And you all are probably responsible for working as a team on that already, right? And some of the standards that we're looking at and some of the citations that could be issued. Right?
Thanks. The same way.
Yeah.
So as you know, speaking with that in the department, pretty much regarding the warehouse, I'm sort of at the warehouse. So that went pretty well, pretty much similar information. We have had 4 stores who were slightly under the regional warehousing program before the next one came out. So we had some experience with the regional programs in one location that has already been inspected under that. Is there relevant? Well, very likely.
Yeah, certainly. One other area that you're likely going to see more activity is heats. So there is a heat NEP. There's also a current rulemaking initiative to roll out a more formalized standard. As I mentioned at the beginning of the class here, right now they're enforcing heat under OSHA's general duty clause. I wouldn't say so successfully either. Since the NEP, the heat NEP was launched in April of 2022. This was March of last year at a conference OSHA presented on what they deemed a success of their heat NEP inspection. There's really only 8 citations issued related to heat, but there was like 1,300 other citations related to a variety of different hazards that they observed going in for heat, right? So the success was we issued all these citations. The enforcement on the heat side, over the course of a year, there was only 8 of them. But the emphasis program gets them in the door, and then plain view comes into place. They see other potential issues or things that they can expand the scope on a different emphasis program, perhaps. And that's where the ball starts moving, right? But this NEP is focused on heat. The goal really is to increase the number of inspections by 100% above baseline average from fiscal year 27 to 2021. So really increasing the number of inspections focused solely on this issue. And it's focused on both indoor and outdoor workplaces. Significant focus though on outdoor workplaces, or indoor workplaces that have folks that work outdoors as well. So it's pretty comprehensive in that regard. Yeah.
Do you explain how they target specific industries or businesses based on?
Yes. Yeah, so we do have NAICS codes in which heat is more of a prevalent issue identified, but it is kind of comprehensive in that it applies to all indoor and outdoor workplaces. So if you have a complaint, perhaps about an employee complaint about heat in the workplace, that could be something that triggers this, right? But there are, for enforcement purposes and targeting enforcement, certain categories that are identified by NAICS code. Yeah, and we can take a look at that. Yeah. Mm-hmm. Yeah, and we can pull up the NAICS codes in that enforcement program, perhaps on a break, and double check that for you, what exactly are in there.
There must be criteria to equal this, but somebody could say, have a complaint about they're hot outside, but it doesn't necessarily, they could be hot, but it could be the lowering standard, right?
So yeah, the question that we have now is kind of related to, well, what kind of triggers the heat inspection protocols, right?
Sure.
And the answer is, I mean, there's really not a fine line of, all right, well, now we're into a high heat category, right? There is guidance on kind of what that looks like. But if an employee is complaining that it's hot in the workplace, for OSHA purposes, they don't need to say, oh, well, they didn't say how hot it was. If it's outside, maybe they're using their reasonable judgment, right? But at the end of the day, right, if it's only 80 degrees and an employer's, or even 75 to 80 degrees, and employees working outside the whole day, OSHA's still concerned about water provisions, shades, break. It's not just the temperature alone, perhaps. It's exactly. So those are the programmed inspections in which they're targeting the certain NAICS codes in those industries, and they're going out for enforcement purposes. But it can be triggered by anything like a complaint, right? A reportable incident. That's where they're programmed inspections. They're targeting them and going out to their workplace in particular because of the criteria and because they're the kind of high risk industry in which this is an issue. But it could come up in any workplace in a different manner, right? A complaint. So the question was, well, heat's covered in the warehouse and distribution NEP, right? You not have to worry about this. No, this could be something, right, where we have multiple emphasis program inspections that are open, and you're not delineating between all right, now we're jumping to talk about this enforcement program. They're just identifying the topics that they're going to cover in an enforcement program. So when you open your establishment database, and they might not even tell you right at the beginning of an inspection that, hey, we're looking at this now because we saw a forklift, right? Or if it's a programmed inspection, they're going to tell you, hey, we're here because it's you fall under the list for the warehouse and NEP, warehouse and distribution NEP, right? Or if you're on OSHA's site-specific targeting list from the data you submit from the 300 log or 300A data, right? They'll tell you, but that's not going to be the sole scope of the inspection. Probably there's going to be line items there. It might be key. It might be the warehouse NEP because they do overlap. And without getting into too much kind of like detail of how that works, if you have an NEP inspection, right? We had one recently, right? They're not going to show up at that facility again for 3 years for the purposes of that inspection. And it's different under different emphasis programs, but for purposes of the program targeting lists, once you receive an NEP inspection, you're not going to be on that list for another 3 years for those issues. So if you have an inspection where you have warehousing and distribution, you have heat covered, you have forklifts covered, that could be a good thing, especially if you get out of that without any citations, because then you're not going to be on that list for X amount of years, right? Doesn't mean they can't come back if there's an incident or a complaint and look at a particular issue. But for the program targeting purposes, once they've completed that type of inspection, you're not going to be regenerated on the random lists that are created for those program inspections.
It's like we have had a complaint before and a high national weather, so it's high heat warning, and we were able to keep from being inspected that was mindfully because of the information provided to OSHA. Pictures of the water coolers, really the temperature, so we were able to prevent from becoming sick. We have some experience with this, and we have the
And these are the things that OSHA is going to be looking for, right? The program itself, do you have any training? They might interview workers to ask about, any symptoms, their working conditions, what type of protocols are in place to address heat, water provisions, shade, break times, those types of things. And they're going to review your 300 logs, right? And any incident reports that might be related to heat that they'll identify and say, oh, can we look at that 301? So these are the types of information that we've seen OSHA traditionally ask for and kind of focus on in these heat inspections. And right, these are the questions. Is there a written program? How are we monitoring ambient temperature and addressing it when it meets certain thresholds, perhaps? And again, there isn't a formal rule right now. There will be sometime soon. There are heat illness rules in a couple different state plans that you guys don't operate in right now. So we don't need to worry about that. But OSHA's using some of those rules as kind of a framework for the development of theirs. And we'll go over that in a few. But right, are there scheduled rest breaks? Do we have additional breaks for hydration? How do we provide employees water, shade if they're working outside? So really it's the administrative and engineering controls that you as an employer have in place to address heats. All right, now we'll go quickly into the rulemaking piece, then we'll touch on managing the inspection and then record keeping. So we've kind of touched on this a little bit, 10 rulemaking priorities. The ones that are important for you all is the e-record keeping portion, the data that you submit on an annual basis, heat illness, and potentially this worker walk around representative rule. So heat illness, this has been a long time in the making. 2021 is when we received the advance notice of proposed rulemaking. Broad rule going to cover indoor and outdoor heat. And here's what it's going to include. don't know the specifics yet, but the written program, engineering controls like your AC, shaded tents, any cooling rooms, and then the administrative controls. Do you have scheduled work breaks, rest cycles, cool down breaks, climatization? How are we introducing employees into high heat environments or those that work outside and acclimate them to working in those environments? Provisions for water, training, medical and exposure monitoring, and then your emergency response plans in the event of a heat illness incident. Right, so we don't need to cover this slide. This is just kind of a long string of where we're at. We're at the National Advisory Committee stage, in which a proposed rule is basically in draft form, and we're ready to kind of roll that out soon. So we covered kind of what these engineering and administrative controls are really going to be looking at, and what OSHA may be inspecting once this rule is finalized. Ventilation, exhaust fans, any portable fans, engineering controls that might be industry specific, rotating shifts, and right, there's no one size fits all to addressing heat, and there's not even like a one size fits all for a particular industry. It's specific to your workplace and how you address it. And there's going to be more guidance and certain requirements and parameters in place for you all to abide by. And on one hand, that might be a good thing, right? Because right now we just have an NEP with some recommendations, and we're going to come out and look at you all for this issue and see how you're handling it. You have rules in place, it may be easier for you to formulate your programs a little better and implement those precautions. All right, so this last piece is pretty important. This is OSHA's walk around inspection rights rulemaking. And this dates back to 2013 interpretation letter. There's an OSHA standard that basically allows representatives authorized by employees to participate in inspections to the extent that they're reasonably necessary to conduct that inspection. And a 2013 interpretation letter issued by OSHA said a union representative at a non-union workplace can participate in an OSHA inspection as long as the employees are okay with it, right? Pretty, yeah, pretty wild. So, yep, a union representative could participate in an OSHA inspection of a non-union workplace if the employees allow. It's a good question. Well, you can't necessarily deny it. There was a challenge to it. So there was a legal challenge. It was overturned. But here we are now in 2023, where new administration is trying to reverse, it's back and forth from administration to administration. But that rule was rescinded. Now we're at the rulemaking stage where they're basically trying to reinstitute that rule. So this is something to keep an eye on. We have a rulemaking coalition where we're advocating against this because non-union workplaces don't want union representatives coming into their workplace just because the employees say, okay, right? You would know because you're going to be with the OSHA inspector, and we're going to touch on that in the managing the inspection part, right? They're not just going to show up in the workplace. Yeah, so it's really we're going back to this. There's no bright line rule of a number of employees. So if there is interjection, and I'll say this, we haven't seen this come up as an issue, but this is something that is now at the forefront. We're dealing with an administration that's more pro-union, and there's been significantly more union activity over the past few years, right? So this is one more notch for union representatives to use to try and get into non-union workplaces. It's not finalized yet. It's in the rulemaking stage, and there's significant industry backlash about this. but something that you all should keep an eye on.
After my asking for our feedback, because there is one problem here, so we can not in terms of that. So if you guys have anything that specific comes with me, they're, I think they're having this in the comments, so it's not be necessary. But into the before that, but it's something proprietary productions, something with manufacturing, if there's something
All right, so the next part here, we're just going to cover this pretty quickly. This is managing OSHA inspections and how to prepare for them, right? So when we're talking about what happens when OSHA shows up, well, we're going to start with the goals of managing an inspection. You want to control the flow of information, starting with having one point person to make any communication, send any documents to OSHA. The last thing you want is multiple voices in the room sharing information that isn't captured, because, right, what you say can and will be used against you. You don't know what is being said or who's saying it. And mind you, you can't control what employees are saying. And we'll touch on employee interviews here. But for management purposes, we talked about employer knowledge, one of the key elements, right, that OSHA is going to be using to establish employer knowledge, management interviews. So who's saying what? Control that flow of information and have one concise voice for the company, right? Minimize the business disruption, right? So trying to get OSHA out as quick as possible. Casting the workplace in the best light. And you guys have great safety programs, right, in general, and you're able to manage these inspections probably pretty successfully already. These are just some things to bear in mind. And start trying to identify potential problems early. It sounds like you guys are already doing that with some audits and corrective actions in ways that you're taking care of the workplace and being proactive about it. So talking about OSHA's inspection rights, that comes from section 8A of the OSHA Act. We covered this already. They can come at any time, reasonable times to the workplace during regular business hours and at other reasonable times. The stages of the inspection, this might look familiar, right? They're going to show up. There's going to be introductions and an opening conference, what they're there for. And this is where you might hear, we're here for the warehouse distribution NEP, showed up on the list. We're here for a complaint. We're here because you reported a serious injury, an inpatient hospitalization, right? And we're here to investigate that. So they'll go over the scope of the inspection, and that's where you can perhaps push back. If, for example, you already had an NEP inspection within the last 3 years, and they're there to do another one. Say, well, we were already on that list last year. You were here for the inspection. It's already done. We shouldn't be back on the list, right? Push back. Now, the next phase, right? They go through the opening conference. There's going to be a walk around, and they may ask for documents before or after that walk around. Our experience, they're asking for documentation typically after a walk around once they identify particular issues that they want to hone in on. The one thing that they'll ask for at the opening conference documentation wise is the OSHA 300 logs, typically for the past 3 or 4 years. Then we're going to move on to any employee interviews. Those may be on site during the walk around. They may ask, okay, can I speak to this employee? Try and minimize the disruption that we talked about, right? Coordinate those interviews, try and give yourself an opportunity to talk to the employee, give them a heads up about what's going on, right? Sometimes employees are just going to see management walking around with someone in a vest, right? And not know what's going on and say, oh, you have to talk to this person. You have an opportunity to chat with an employee and say, hey, here's some of the issues that they're looking at, review those employee rights under the OSHA Act, which we're going to talk about here in a slide or two. That's really beneficial to kind of making the employee comfortable, and you can kind of get a sense of maybe what they will be saying to some extent, right?
It's a good opportunity to remind them of training, right?
Yeah.
Hey, remember you took I'll let training remember you start.
Exactly, yeah, if you know what these issues are, a refresher for that employee and a review of their rights under the act is certainly helpful.
Question around the
Mhm.
I think it's good for everyone. As you and I said it about this. We had it in an OSHA officer at a store. It was at the point where they were doing employee interviews. I was on the phone assisting, I wasn't there. Aaron, you might have done that. So he asked to introduce the employees. She was interviewing an employee and walked with just that employee. And I heard about it and I want to know our rights and rights and say to that OSHA person, we're gonna give you a room to do your interview, because I don't think we should have an employee walking the store and being interviewed with an OSHA officer. We're not there to see and hear and take notes. They can start pointing things out and it can get really crazy. And we have the right to say, we would like you to do your interviews in this conference room.
Yeah,
Just
so
within, you know, they're with the employee by themselves.
Mhm.
But not wandering the store and the employees pointing all over the place and.
yeah, so the question here is about kind of managing employee interviews. And we're gonna cover that and we'll do it right now, right? Yeah, the idea of letting an employee walk around with an OSHA inspector, you don't want to do that, right? One of the goals is limiting business disruption. That employee's supposed to be working. So to the extent that you want to control those employee interviews, you ask the inspector, hey, give me a list of whoever you'd like to speak to, and we'll coordinate those interviews, get you set up in a room with that person and record it off there, right? You can certainly coordinate those interviews. But if it's like a stop and ask employees a couple of questions during the walkthrough, that's totally fine. But if we're talking about a 30 minute interview, yeah, they shouldn't be walking around the facility. It should be in a conference room and take them to those. Yes.
What's going on.
Yeah.
And I think that needs to be put in some of our training. Because we're not always there as part of the walk.
Mhm.
A lot of times we're on the phone coaching at the store. You know, when we do the opening via phone, we're not, we can't just. go.
Yeah, well, during that opening conference, you can say to the inspector, hey, any interviews that you want to do, let me know so we can coordinate those and set up a conference room for you to talk to those employees.
And another part of that is when we're talking about kind of scheduling that and controlling that is, and Dan mentioned this, but just to reemphasize is, they don't have to do the employee interviews in the moment, right? They don't get to see someone walk and be like, I want to interview them right now. You know, if again, a couple questions, hey, you know, this, that, and the other, okay, but an actual interview, business disruption, purposes of safety. You know, I guess a store, so it's maybe there's some aspects of safety, but you know, you have a facility where you got a lot of moving things happening, a lot of parts or industrial trucks running around or loading and unloading. I mean, do you really want people walking around having a conversation, maybe not paying attention to their surroundings the way they should be? I think that's another way that you can tell them, you know, we need to get this into an environment where you can have your interviews, you can do it in a place where you can hear everything, you're also not disrupting, you know, the business, you're not potentially doing an unsafe act, but you know, we also can do it in a way that's more efficient. Right? You're not going to come and do an interview now and show up 2 days later and do another interview and then show up 3 days later and do another one. Tell us who it is. We will make it as organized as possible if they want to talk to you.
We've done that on the warehouse side. They want to speak to the people and we figured it out. We didn't drop everything. You get some of it right now. And then
Yeah.
they had the right to ask for their right, of course.
I agree.
No, so we're gonna, yeah, well, yes and no. They can deny, right? But OSHA does have subpoena authority, and with a subpoena comes, you must. Yeah. In the moment, an employee can say, no, I don't want to talk to you. Yeah,
You have to
Yeah.
go a different route, you know. it's
Right.
Side. I mean, it can happen. They have the authority to speak,
Yeah.
right, seeking, witness interview. But I mean, in the instant of OSHA wants to interview you. No, I'm okay. That's perfect.
Mhm. So let's just skip ahead here. So, yeah. Here we go. OSHA inspection interviews. So when we're talking about employee interviews, and again, you're gonna get these slides, and I think the next slide we have, employee interview tips and their rights. So OSHA can demand a private interview with employees. This is all outlined in the field operations manual. The right to privacy belongs to the employee, though. They do have the right to say, I don't want to speak to you. That's totally fine. And they also have the right to request to have a representative accompany them or sit in on that interview. We get a lot of pushback from OSHA on that. And, you know, when push comes to shove, we don't want to necessarily be creating a hostile environment with the people that are regulating us either. So if an employee is saying, well, I want a management representative here, and OSHA is saying, no, the employee at that point can just say, I don't want to speak to OSHA, right? And they can't do anything about it unless they go out and get a subpoena and force that person to sit down for an interview on a deposition. But you as an employer don't have the right to sit in on an employee interview. That belongs to the employee. Right, management, totally different. That is the employer's right to sit in on that management interview. So we could have like an hour-long presentation on that too. It gets into a host of different factors, right? If you are someone that controls employees, you're setting schedules, you're responsible for, implementation of programs, you may be considered management, right? Your traditional management. And the gray area is where we have like a team lead, right? A shift lead. Is that person really management, or are they an hourly employee, right? If you're a salaried employee, more likely you're probably going to be seen on the management side if you have responsibility for overseeing employees, implementing programs. A lot of different factors that go into it. But feel free to chime in on that. It's not a black and white answer, right?
It isn't, and it's also a strategic thing that we have to think through during an investigation, because if we claim someone is a supervisor, we claim their management for the purpose of moving forward in this investigation. I mean, what does that mean? What's the first bullet up there? Right? On the management side, supervisor's knowledge and admissions are imputed to the employer. So if you're claiming that person as such, you're claiming what they're saying, right? So that's something that is, there's a lot of gray area here. We could probably an hour's not enough to have that discussion, and really do it justice. But part of it is, does that person fill that? And if it is a question of maybe not, we don't know, maybe when they're doing this job, but not that job, what is this investigation related to specifically? Is it when they're doing job A or job B? Is it when their direct supervisors out of the office or, on vacation and they assume different roles? But when you claim that person, when you say we are asserting our right to sit in during the management interview, well, guess what? They've just been marked as management by OSHA. So there's sometimes a strategic decision there. And, what are they going to communicate? Do they know what they're going to communicate? What is their actual role versus what do they think or what does OSHA think their role is? Sometimes we have to try to correct that impression, right? Correct whatever conclusion that the agency has come to. It may be incorrect, right? It may be that they think someone's got a lot more authority than they do because the way that person talks to them, their own way to approach them, or vice versa. So.
No, all good. Yeah. The key thing when we're talking about managing these inspections, right, is you should have some protocols in place from the safety and health perspective that is trickled down to management. So they know what happens when OSHA shows up. Here's what I need to do, X, Y, and Z. Here's how I should handle employee interviews, management interviews. And you guys are probably going to get a phone call anyway if OSHA shows up, and you can help through that process. But having that baseline knowledge of, all right, here's what I need to do moving forward. Here's who I need to pick up the phone and call is really critical in those first steps, right? Especially when we're talking about interviews and the walk around inspection, document productions. You know, we get calls sometimes from clients where it's like, oh yeah, I provided them X, Y, and Z already. I demonstrated to them how we lock out a machine. And all of a sudden it's like damage is done now, right? It's pretty tough. You don't have to do any of that stuff. You don't have to demonstrate anything. You don't have to do work for OSHA. So just wanted to cover this slide really quick. We've gone over the opening conference, employee interviews, management interviews. Narrowing the scope of the inspection to the extent possible, right? If it's related to a complaint, it's limited solely to the alleged hazards in that complaint. An incident, take them exactly where the incident occurred, get them out as quick as possible. Don't let them just walk around or otherwise take them around the entire facility. Always accompany the compliance officer. Don't let them just walk around freely. They should be announcing their presence as soon as they come into any one of your locations. It's not going to be a covert operation. They can certainly see stuff from the parking lot, plain view, perhaps, right? But for purposes of opening and inspection, there's really no like covert inspections going on, right? Make sure that they're following any safety rules that they're required, if any PPEs required, anything like that. Make sure that they're donning that. And if a compliance officer makes a comment during a walk around inspection, right? Hey, you should fix that. This looks like a hazard, XYZ. One of the things that can trip up some employers is, right, an admission where the management personnel walking around with that inspector says, oh, I've been meaning to fix that. Yeah, totally a hazard. I'll fix it right now. Boom, you're getting a citation, right? You fixed it. You admitted that there was a hazard. You admitted that there was a violation. Just go fix it. Don't say much. Don't say anything. Take the side-by-side photos, walk them around, answer whatever questions that they may ask of you. Just facts. You don't have to be providing any opinions, speculation, right? Just stick to the facts. Answer the question, answer the question that was asked. Don't offer up any additional information and just keep walking. It's on them to get information from you. Don't provide it to them freely, right? Yeah.
Also, you know, watch them, right? Make sure they're not doing anything unsafe, but also, you know, watch out for the whole contradiction thing, right? That's a horribly unsafe condition that I'm observing, yet I'm just gonna go walk right next to it or engage in it. It's not something we see often, but it is kind of something that if we do see, we want to make note of, because it's defensive. I mean, I apologize, I had to step outside because literally we have a client right now who is going through the process of they're changing out the investigator on a investigation because the person cited an electrical hazard and then went and walked around the MCC room without PPE when he said that it was, you know, a serious violation of all these different PPE requirements and lockout tag out. So watch them, you know, you're accompanying them so that you can see what they're looking at. You can take photos, you can take notes, you can have your contemporaneous recollection so that they're not the only ones with that, but also you're monitoring them, making sure that they're not, you know, being contradictory in what they're telling you versus what they're doing.
You bring that up to the individual, or do you bring it up to the
That's a good question. I think it depends on the nature of it, right? You know, if it's in the process of don't have enforcement in front of you yet, you know, it's probably something where you're talking, well, I think that's a violation. Well, how is it a violation if you just walked right through it, right? Obviously, it wasn't that dangerous, or else you wouldn't have done that. I think you have to be measured in how you have those conversations. Obviously, we never want to be too argumentative with them because that has the way to spin things in a negative fashion. But, you know, when it comes up that maybe you do receive enforcement and you are now in the
process of doing an informal conference or even formally contesting it, it absolutely comes up to their supervisor at that point in time. And if it's something, you know, that's talking about it from the stance of it being a defensive, right, to enforcement. If it's so bad to the point that they're just being unsafe and it's making you or your employees uncomfortable because they're being unsafe and how they're acting, then you don't wait. You immediately bring that to their attention and or their supervisors. But yeah.
Photos of whatever is that person is photos of, or whatever you know, you're looking at, and you know, right now you see. Taking those photos is very helpful, especially for you that to see what things that you saw and taking notes. That's hard to do when you're paying attention to where they're kind of walking and what they're asking and who's going on. But notes from that time, exactly what it said or exactly the box. So all that is really, really helpful after that. It was a distance. Yeah, so exactly right where they were.
I would say that do that, but then also try and get a different perspective. Because a lot of times, you know, call it the big fish stories, right? You know, they take a picture of a guard, it's a hole in the guard, and they're like, oh my God, yeah, got it. And it's an 8x10 photo of an open. Yeah, but you step back a foot or two and it's an inch and a half by an inch and a half. You know, and you can't fit more than 2 fingers in there, and the moving machine part is 8 inches away. There's no exposure there. Right? You know, you can't wiggling around. I don't know, double jointed. So take it from the same perspective so that you know what they're looking at and what they're going to include in violation. And then consider what other perspective may be helpful to you in terms of understanding more fully what the violation might be, what the condition is, or whether or not it's actually legitimate, how it's being prevented. So that's I think one. And then also on the photo side, I'm sorry.
I was gonna say, we had a case recently, the fall protection case, where the OSHA took the photo, the 4-foot threshold, right? And the measurement was up to the top of the curb, the bump, to prevent forklifts from kind of going into a truck well. And OSHA said, oh, it's a fall of more than 4 feet, but really from the walking working surface, not the top of the curb, it was like 38 inches. But they take that photo and say, oh, yeah, here we go.
4.5. And laid down the compliance officer's photo, which we took side by side. And then we laid down a photo from different perspectives and walked out with it. So I mean, it's just kind of looking at that. But do you know that though? Photos, you know, they great defensive material, great for allowing us and our internal counsel and our internal safety team to know what exactly is occurring, but be careful, don't take photos of conditions that are in violation, right? Those are gonna be something that is discoverable later on, that can be, you know, sought through discovery if we're happening. So just be careful what's happening. Don't recreate a volatile condition. You want to let me leave all of the condition and try and use it as a defensive material. That's always a big no-no, right? Don't show me something like this is safe. See, here's me showing you again how safe it was. That's kind of gone the other way on a couple companies with us. So just yeah, they're great, but just be mindful of where you're looking at, what you're looking at.
So this slide, we've already covered the bulk of this, but a couple of things I do want to point out. OSHA, a lot of times the compliance officer at the end of an interview will say, oh, would you like to sign your statement? That is not a statement. That is a transcription of their notes of what you said. It is not your written signed statement. So when OSHA says, oh, would you like to sign a statement? The answer should be no, right? Did I write that? No. Did I say that? You didn't say that verbatim, right? Unless they are typing up and writing every single word that you said, that is not your statement. So do not sign anything. And you can tell employees that, right? Just what I told you. Is that your written words verbatim? Would you sign something that isn't written by you, wasn't explicitly stated by you? No, all right, well, there's your answer. Don't sign the statement and we don't recommend doing so. And then the other piece is about being recorded. Don't have, you don't have to be recorded. Employees, they have the option to if they'd like. We recommend that they don't, right? And employees more often than not, right, are a little hesitant to speak to the government, you know, unless it's someone that has angst against the company. But that's another way, right, that we say control the interviews, try and select employees, right? If they want to interview people from this section of the warehouse, okay, now we have the ability to select maybe 2, 3 of those employees, maybe some that have 10, 15 years experience, that know the rules very well, are eloquent in speaking about those, right? Okay. So now we're on to the last section, the record keeping and reporting piece. I don't know if you want to take a short break now or dive right into it. This should be like an hour for record keeping and reporting, and then the e-record keeping piece will be 15, 20 minutes. Okay. All right, we're going to kick off the last section of the training today with record keeping and reporting, and we're going to touch at the very end on e-record keeping. So we're going to start initially with the importance of OSHA record keeping and reporting. And there's a few key considerations here, and we've touched on a few of these quite extensively throughout the training today already. And that's that injury data determines whether you qualify for certain programs, emphasis programs, but in particular OSHA's site-specific targeting enforcement program. That is the basis of the e-record keeping rule, was to collect 300A data to target high rate employers, high injury and illness rate establishments. We know that if you submit data, regardless of what your injury and illness rate is, you can be subject to an SST inspection, because they create those lists under the SST program based on those with high injury rates, those with increasing injury rates over the past 3 years, non-responders, and then also a category of low rate establishments. So what does that mean? If you submit data, you can be subject to an SST inspection, regardless of how good your injury and illness rate is or how safe your establishment is. Record keeping is one of those few regulatory categories that can be cited on per instance basis. We went over that, so you can get the multiple penalties, multiple citations for record keeping violations. The e-record keeping data, that data that you submit on the 300 or on the injury tracking application, that is publicly available, right? Anyone can go on OSHA's website, look at that data. Union representatives, plaintiffs' attorneys, anyone that wants to get it has access to it, right? The injury data can affect your workers' compensation rate modifier, right? Your eligibility for voluntary protection programs, if that's something that that you all are in. We talked about the emphasis programs and the high injury rates in certain industries that are targeted under a variety of emphasis programs, right? The warehouse and distribution center, NEPs, falls, or not falls, I should say, but heat. And OSHA injury and illness record keeping is a no-fault system, right? So there's no defense for the employee misconduct piece, right? If you have a record keeping violation, it's likely a record keeping violation, unless you have some determination that, well, this wasn't work related, right? This wasn't a new case. We updated the prior log. So it's very different in your traditional sense of a regular safety and health violation, right? Or a citation. The defenses are very limited, and that's why it's important to get it right in the first instance. And we have reiterated this a couple times. The information that's on your injury and illness record keeping forms can be used to establish employer knowledge and recognition of a hazard for purposes of the general duty clause or any substantive standard that may be applicable, right? So we want to be careful in the information that we're putting on these forms. You can update them, right? Your 300 log in particular, you have an obligation under the regulations to retain and update them for 5 years. So there's no harm in taking a look at those periodically, doing some audits and updating them if necessary, right? So OSHA record keeping, the Section 8C of the OSHA Act, this is what authorizes the Secretary of Labor to keep records of work-related deaths, injuries, and illnesses. So this is kind of the genesis of OSHA record keeping as set out by Congress. The regulations themselves that are implemented by OSHA, that's 29 CFR 1904. And the interesting piece here is you need to record injuries and illnesses of employees on your payroll and employees you supervise day to day. This probably isn't so much of an issue in your industry, but more so in construction context where you may be dealing with different specialty contractors that may or may not be under your control, perhaps, or really working for you and what OSHA would consider as one of your employees, right? But typically it's going to be employees on your payroll and employees that you supervise on a day-to-day basis. Those are the employees that you're going to need to record any injuries or illnesses on the log. The same goes for reporting, right? So what are the goals of OSHA record keeping? From the employer side of things, it's to identify hazards and trends and implement corrective actions and enhancements. Now we have the Bureau of Labor Statistics and OSHA. I briefly went over this as well, that there is kind of this relationship. BLS does collect data on a random basis. You may get a BLS request for data specific to certain establishments. You don't have to submit data to BLS on an annual basis like you do OSHA. But when you do get one of those BLS requests, you are obligated to respond. Usually it's, maybe one to a handful of particular establishments in a certain area. And BLS is using that data, right, to track workplace injuries and illnesses and gather statistical data, which is in turn also used by OSHA. What's OSHA using your records for? Well, we already know it's to identify areas for special enforcement emphasis, particular areas in which they need to initiate rulemaking, areas alleged or hazards that need to be addressed more thoroughly in a rule, right? Compliance assistance, where we're going to focus our resources on providing more assistance to employers to help them comply with these.
No, actually, I follow on over here, and there's consistent stores that show up in facilities that show up every year.
Really? Okay.
Yeah, is that normal?
It's really at random. Yeah, that the establishments that get selected, so they may be the unlucky ones. Yeah, it's really, that's interesting. If every single one of those same establishments every year is on the list. Huh. Yeah, typically we'll see, one store here, the next year it might be a handful of stores somewhere else. And
It's not a specific survey, sometimes they ask for specific technology surveys. Times and then we'll probably plan it and then what case. That's the only thing that's done.
Interesting. Yeah. The typical survey of injuries and illnesses from BLS, this may be something different or more specific. I'm not sure about that. Have you ever dealt with anything where they're asking about specific cases?
No, that's the.
Yeah, that's,
Maybe it'd be helpful, afterwards,
Yeah.
share that, let's see what the request is. And then we better answer the question, but that's usually it's one of the requests for overall data from the specifics out because it's not maybe even a specific injury or incident. But, yeah.
Hmm.
A lot of times, I mean, a lot of them are questioning how old the employee is.
Okay. All right, yeah, we can talk about that afterwards. The last two pieces, what OSHA is using this for, to focus and expand individual inspections, right? They're gonna ask for your 300 logs and injury and illness records at the start of the inspection. By regulation, you have to provide them to OSHA within 4 hours of request. So keep that in mind, that is a rule. And they're gonna look at those to potentially identify hazards that may be popping up more so in your workplace than they would otherwise like or see in industry averages, right? And that's identifies them and provides a roadmap for them to look at things during their inspection. And then they use what's on your injury and illness records to potentially support citations for that employer knowledge piece, and the heightened awareness for willful characterizations. So again, important to get these things right in the first instance, just so you're not finding yourself in hot water during an inspection or elsewhere. So these are just some quick photos of what these forms look like. You're all aware of them. We're talking about the OSHA 300 log, 301 incident report, the 300A annual summary, and the privacy concern list. Those are the 4 primary categories of injury and illness records that we're talking about here. So here's the 300 log. We're going to dive into these in a little more detail. The 301 incident report and the 300A annual summary. So these are all familiar forms to you all, right? So how do we as employers use these forms, right? So we're going to obtain information, report from employees about workplace injuries and incidents that happen, injuries and illnesses, I should say. And anything that is deemed to be recordable is going to be recorded on that 300 log. You're going to complete a 301 incident report for each case that is recorded on the 300 log. And then as it relates to the 300A annual summary, the 300A form, right? We are going to prepare, certify, and post that at the end of every year. It needs to be posted in the workplace from February through April for 2 months. We'll talk about the certification piece in a little bit here. And then the final component is you're retaining and maintaining those records for 5 years. As I mentioned before, you have an obligation to update the 300 logs for a 5-year period. The 301 incident reports and the 300A annual summaries, you do not have to update those over that 5-year period. It's only the 300 logs, okay? So the basic record keeping requirements. When an injury or incident occurs, or injury or illness, I should say, not incident, you have 7 calendar days to record that on the 300 log. And here is the criteria that needs to be met. We're going to dive into each one of these in a little more detail, but you need to record an injury, illness, or fatality that is 1, it's work-related, 2, it's a new case, and then 3, it meets at least one of the general recording criteria in 1904, or it meets one of the special recording criteria in 1904.8 through .12. So we're going to dive into each one of these, but these are the 3 key components that we need to analyze when determining whether a case is recordable, okay? So what is an injury or illness? OSHA has a really broad definition and interpretation of what is an injury or illness. It's any abnormal condition or disorder. So you see some of the examples that we have on the screen here: cuts, fractures, sprains, amputations, illnesses. We're talking about acute and chronic illnesses like skin or respiratory diseases or poisonings, but it could be, you know, I tweaked my back. I have a stinging pain, you know, in my knee. If that results, if it's, and we're going to go through this analysis, right? If it's work related, it meets one of the general recording criteria. Perhaps it results in medical treatment beyond first aid, right? and they had to go to the doctor, they're prescribed a prescription to treat that pain. That is recordable. You might not have a cut, you might not have a fracture. It might not even be characterized as a strain, but it's an abnormal condition, as OSHA would define it, that triggers that. So think of it, it's a very broad definition, and it doesn't necessarily have to be the cut, the fracture, the sprain, or some type of amputation. It can be very, very minor, but if it results in medical treatment beyond first aid or days away from work, restricted job transfer, these are the general recording criteria that we're going to talk about in a few slides as well. Yes. We're going to get to that in a second here too. So we're going to stick first with, oh, maybe we can go to the, here we go. New case, right? Is the injury or illness a new case? So a new case occurs when an employee has, one, never previously reported any similar signs or symptoms of this injury or illness. And if they've recovered completely from a prior injury or illness, but workplace events or exposures cause the signs or symptoms to reappear, that will be a new case, right? So the scenarios that we see where you may have a case that's already recorded on the log is a situation where someone may have a strain and they're not fully recovered yet, right? And there's some type of aggravation. Say they were out, for example, days away from work due to a back strain. They're out for 10 days, they're not fully recovered, and they come back to work anyway. They work for a couple weeks, and then all of a sudden there's an aggravation of that, and they have to go back out. So if they are fully recovered and it happens again, that is going to be a new case. So this is one of those gray areas. It's kind of tough, right? To make that evaluation, and there's going to have to be some discussion. A lot of times you're going to have documentation, perhaps, if an employee is returning to work and the doctor says, there is still lingering pain upon their return to work. Well, you have some basis for, all right, if they're not fully recovered yet. And then if they have that injury again, or there's some aggravation, that may not be a new case, right? But if they are fully recovered, there's no restrictions or anything like that, and something else happens again months down the line, that's going to be a new case. So it's the recovery. Yeah.
Provider might have said anyway, no, it's that there's something very something.
Mm-hmm.
But on your side, they can say,
You're getting the report of the injury or illness from the employee.
And then we're going to split hairs, and this is relevant right now. Using the first report of injury. Now, whether they determine whether they think they're on that.
Whether they're fully recovered.
Yeah, who's determining whether they're fully recovered? Whether they go back. Well, really, because they could still have a low line back. It's not as low level. So
yeah.
I think so. So the responsibility will go back to the employer, like to say, we wouldn't say it's a case. Because we view this as not a concern as a pre-existing. So then you would have to say, here's why. You don't have to, you don't need to be specific on that point. But saying you got really from the work, you got it in the those were both your case. But it is on the employer to show why you say that wasn't. I think what Nancy's asking is, You can't rely solely on the employee providing medical information to make that determination. You get it from outside. Medical providers, correct? So it's how you need to get from an employee. It's in that situation.
Mhm.
Get right to the medical.
Yeah, so OSHA, the OSHA's purview is right when we're looking at the record keeping analysis, if there is a doctor's note that says one thing, even if we dispute it, OSHA is going to be deferring to that medical diagnosis, whatever it is, talking about an amputation and the reporting side of things. If we don't think it's an amputation, but that medical record says partial amputation, that's what you need to rely on. There's deference to the medical determination in the record keeping and reporting. Yeah, so the discussion here is about access and requesting information from an employee about their medical status, return to work status, right? You can certainly ask for information to help assist you in making that determination, right? There's no problem in asking for that. I'm sorry, I didn't hear that question. So yeah, you're not going to get information from the hospital, like a direct request, right, for their medical information. But following up with that employee, like if you have a return to work process in place, right?
You need to let them know that they have to give you that document.
Right. Right. Yeah. Yeah.
I know it feels like we're getting almost
Mm. Yeah. Yeah.
Well, but Dan, I mean, Dan just mentioned about the importance of kind of having that return to work process, right? And that's how you can establish that there is a system that takes place. You know, we're checking the boxes on the return to work, and one of those things is having provided. Right.
Mm-hmm. And when we're talking about the new case piece, I will say that this isn't something that we see a lot of, right? Where we're updating older cases. I mean, it may pop up in the musculoskeletal disorder context, right? But that's really all we're talking about in that context. So, you know, if someone has reported similar signs or symptoms before, they haven't completely recovered, that's a conversation that you can have. If they haven't completely recovered for that and they're getting medication perhaps still, right? That's evidence that, right, this may not be a new case. This could be an aggravation of an existing case. And then you can update those logs. And it's a conversation that you have with employees too, right? It doesn't necessarily have to be records heavy if the employee is providing information to you as well, and you're determining that it's not a new case. That's a good thing, right? Because you don't have another new case on your 300 log. Because you have a new case on your 300 log, your injury and illness rate is going to go up, right?
We've seen certain qualifications that have required of a person who actually makes that determination. That they're has medical knowledge. Is that ever come up in court that a company maybe doesn't have the right training to make that determination?
So we'll get into really the determination about what is like medical treatment.
Yeah.
So basically any type of care or treatment that is not first aid that's outlined in OSHA's regulation is going to be medical treatment. And we'll get to, I'm jumping around here a little bit. No worries.
More so the determination of whether or not it's continuing the first school or the first aid.
What I'm asking is the person at records who checks that box of this OSHA, they have to have certain qualifications to be allowed to make that determination. Have you ever had a case where someone's challenged, OSHA's challenged a company's ability to make the determination that they're looking at? It's the right people are looking at this.
Yeah, we've had instances in which OSHA has said, hey, this case should have been recorded, right? And they can do kind of a synopsis of information that, right, there's a kind of a correlation between what's likely going to be on your 300 logs and the workers' comp claims. So there's kind of the correlation of that, and there's different ways in which they might find out about injuries or illnesses, right? During inspections, reportable events. If you report an incident, it's definitely going to be recordable, probably, right? The person went to the hospital, in all likelihood received either medical treatment beyond first aid or is out or on some job restriction. It's going to be recordable. It's on the employer to make that determination and filling out the log, right? And there's different ways to go about getting this information, but when we're talking about gathering information to do this analysis, yeah, it's on the employer, and it could be a safety or health professional, it could be HR. There's a variety of different people that are maintaining and updating and filling out the 300 logs at our different client sites.
Yeah.
It can be anyone.
It's not necessarily that there's like certification that you should have in order to make this determination, right?
Mhm.
If you're having a question of you didn't have the right things, you didn't come to the right conclusion, it's probably less so going to be an argument that you weren't qualified to make that, and more so you didn't look at the right information. Right, it's going to come back at, the company didn't put it as in the position to evaluate the right information and come to the same conclusion that OSHA thinks is correct, as opposed to, Lee doesn't have the appropriate training in order to make that, or she isn't qualified to make it. There is a distinction there.
There's really good point about it earlier though, about state can pull up all the comp pieces compared to the OSHA log, and then make that correlation and say, why is, it's not matching here, right?
Yeah, we don't see it that often, but we do have cases in which there's a record keeping violation for what OSHA deems to be failure to record a case. More often than not, it's because there's been a reportable event, right? At some point, it's not properly recorded, or one of the other common record keeping violations is not having the correct information filled out there. You're not complying with the regulations on the detail in which we need to provide. But in terms of, well, this is a new case, this isn't not a new case, never had an argument about that at all. So, now we are kind of going through, right? Is it a new case? Now we're going to transition. Is it work related? Have you all heard of the geographic presumption, right? So anything basically that happens in the workplace, it's going to be presumed to be work related, injury or illness, if it results from an event where an employee is at work or is present at a condition of work. Yes. Question.
Would that constitute like two employees in a parking lot?
Yeah, so there's a couple, that's a really complex question, and there's, yeah, so, yeah, let me dissect that a little bit for you. So the parking lot is considered part of an employer's establishment. There's the side, so if these employees are commuting into work, they're on their normal commute and an accident occurs in the parking lot, I don't believe that is going to be recordable. Now, if they are fooling around on a break, cruising around the parking lot, that geographic presumption would apply. And that would potentially be considered work-related. There's certain exceptions, right? That we'll dive into here. But there's a ton of different OSHA interpretation letters on accidents in the parking lot, right? If an employee steps out of the parking lot or steps out of their car, they've parked, the commute is over, and they're stepping out of the parking lot, they slip on ice, that's work-related. That's covered. Yeah.
So if I'm leaving work and I hit a customer's car and stop like in front of the store.
Are you speaking to?
No.
Yeah. Yeah, yeah. Yeah, no. And there's a ton of different like crazy scenarios that pop up, and we can have like a more thorough discussion about each one of those. But the general framework, right, is that the parking lot is considered part of the establishment, the employer's establishment, but it all depends. Are we on the commute, right? If the accident occurs on the commute in the parking lot, that may not be recordable, right?
It's the end of the shift.
End of the shift.
Shifts over, getting in the car to drive home, hit somebody before they leave. Well,
Yeah,
if it's in the middle of the day, in order they're trying to get something and decide to park in a different spot, probably, yes.
yeah.
It's
It's on a break.
A lot of gray area.
There's a lot of gray area in the parking lot, and we can provide you all there in the materials that we're going to provide. There's some information, think about that, but there's a lot of interpretation letters that be happy to send your way, and we can kind of hash out different scenarios that might pop up. There's a lot of FAQs that are covered on parking lots too. So that one, it's like really fact specific. But yeah, no problem. We've gotten a lot of questions about that in the record keeping class, the parking lot pieces, and there's always something new where, oh, well, our employees park in the church parking lot and then they cross this road. And then once they're in our parking lot, they get hit. What happens then? Or then they walk. Yeah, right. Yeah.
Designated parking space, right, designated area.
Mhm.
They park outside of designated. Oh.
So in that case, it's all a lot of questions coming in. So I'll repeat this one. If there's a scenario in which an employee parks in maybe a public parking area on the street or another parking lot, and they slip and fall, is that going to be work related and potentially recordable, right? No, that is not considered part of the employer's establishment. You have to have some type of control or the ability to control that premise. And if you don't, that's not covered. Okay. Geographic presumption. Yeah. Parking lot accidents. Yep. So work environment, quickly, establishment where or another location where one or more employees are working or present as a condition of employment. So it doesn't necessarily have to be your workplace, but if they are present in a work location, it's as a condition of their employment. This happens a lot in different industries, right? Where they're traveling, mobile employees, that may be in construction perhaps or elsewhere. Work from home. Yeah. So there is, yeah. It does pop up in how you handle employees working from home and guidance about how they should have a clear workspace. That comes up more so in a workers' comp issue than I would say OSHA, right? Because we don't have control over that workplace, but I know that's a big question on workers' comp side of things, how that factors in. I'm not an expert on that though. So eggshell exception. This is common kind of old law school tort saying, right? That you take your plaintiff as they come, basically. So it doesn't matter if another employee wouldn't have been injured in the same way or to the same degree. It could be the slightest of little things. but say someone, it would have been a minor cut to anyone else, covered up with a Band-Aid, but someone has, a bleeding disorder, and it becomes this really significant case, right? Requiring medical treatment, maybe it's reportable. You take them as they come, right? So work-related for injuries and illnesses, this is where we're going to talk about the significant aggravation of pre-existing conditions. And basically, a case is going to be work-related if the incident caused or contributed to the condition. So the work event or exposure, it just needs to be an identifiable cause of the injury or illness. It doesn't need to be the sole cause of the injury or illness. So we see this a lot where there may not be any type of significant injury at all. There might be this very minor cut that doesn't even require first aid, for example, but someone doesn't take care of themselves and it gets infected, and then they need their finger cut off. Medical amputation, right? That is going to be considered work-related because there was an event in the workplace that caused or contributed to that injury, and you take the employee as they come. And that's OSHA's purview on those issues, right? Significant aggravation of a pre-existing condition. So if you have a workplace event that aggravates a pre-existing injury such that it results in a new, more severe or new record-keeping outcome. So, right, what we're looking at is death, loss of consciousness, 1 or more days away from work or restricted work, or medical treatment, or some type of change in treatment. That does trigger the work-related analysis. So this could be someone with a back injury or some type of back condition that was completely unrelated to the workplace initially, right? It could have been something that's been nagging them from sports or whatever it may be, and it's significantly aggravated by some event or exposure in the workplace that results in one of these outcomes. That is going to be considered work-related, okay? And what you see on the screen here is just kind of a map. It's in OSHA's regulations, I believe, or one of the appendixes. That kind of is a flow chart of how you make this analysis from start to finish, right? Did the employee experience an injury or illness? If they did, was it work-related? Is it a new case? If it is, does it meet one of the general or special recording criteria? And I think that's what we're going to get into in the next slide or two. So there's a couple exceptions to the geographic presumption. One, auto accident in company parking lot or access road while commuting. There's the first one. Signs or symptoms surface at work, but it's the result of something outside of the work, exposure perhaps to something outside of work at a non-work event. Results from voluntary blood donor, wellness, medical, fitness, or recreational activity. Results from eating or preparing food for personal consumption. Self-grooming, self-medication, intentionally self-inflicted wounds, suicide, the common cold or flu. Working on trying to get COVID moved into that category. Hopefully we'll be successful in that soon. And we're going to cover COVID-19 record keeping here as well. If you're present in a place as a member of the public, right? So if one of your employees is just off shopping as a member of the public at a store, gets injured, that is not work-related. Mental illness. The only caveat to that is if they have a medical note documentation demonstrating that medical or that mental illness may be work-related, and that stresses and instances in the workplace that have contributed to the mental illness. Okay.
We provide the food like today, someone got sick from the I had brought in for this meeting, that would not apply, right?
Yeah, so there is I think it's the like eating or preparing your own personal food, if it's subsidized food from the company or food provided at a party or something like that, I don't believe that is considered work related. I'll double check on that. That's a good question. Yeah. Yeah.
Someone say, well, something doesn't feel like there's open up in there.
Or if someone brings in something from home for everybody else.
Mhm.
That's a question that's come up. During COVID, we had a particularly interesting case that someone brought in food from home. Everyone who ate it seemed to have somehow got COVID afterwards. And there was a question of whether or not the company sanctioned it or provided it.
Mhm.
So, but yeah, there's a lot of questions. This one is particularly one that my food.
Yeah. Yeah, and that question did come up with another employer, and I know one of our other attorneys looked at it, but that was kind of subsidized food on one of their campuses where it was third parties kind of managing the food the vendors there.
Just a question on the laws, if you are, is there a statute of limitation from someone? Let's say a year ago, just to put a number on that, because you're required to be for 5 years.
Mhm.
No, I should go back. I'll take the law.
Yeah, you're gonna have to update it, but there's been litigation on this. It's called the Volks rule, and there's a DC, I think it's the DC Circuit Court decision that argued specifically over the statute of limitations for record keeping purposes, right? Because there is a 6-month statute of limitations for issuing a citation, and the DC Circuit affirmed that. So it's going to be 6 months from the date in which it should have been recorded, right? So for instances that like an employee never told you, yeah. Right. So reporting, you won't be making that report.
What if there's no proof at all? If that occurred? Is it, the employee says it happened?
Well, that's all part of your analysis that you have to do to make a determination whether that's work related. And that's on, there is an onus on the employee to inform you of the injury or illness, right? But if they're,
We prove that the person wasn't.
Right, so joining me just notice that the environmental we file an incident that 1 year ago.
File. Yeah, and is it was supposed to be or would have qualified as a reportable event? Filing workers' comp or oh yeah, I mean yeah, keep going. Yeah, I'm trying to get through. All right, so if the geographic presumption doesn't apply, right, we're going to determine if it's more likely than not that an event or exposure cause contributed to or significantly aggravated a pre-existing condition. Those are the three things we're looking at. It's not obvious that an event or exposure occurred in the work environment. You want to evaluate the employee's job duties, the work environment. Again, it's an investigation by you all to do this analysis, right? All right, we covered whether the injury or illness is a new case. Now we're on to the general recording criteria and the special recording criteria, right? There's the three categories that we're looking at when we make this analysis. It's work related, it's a new case. Now it doesn't meet one of the special or general recording criteria. Here's what the general recording criteria is: death, loss of consciousness, restricted work or job transfer, days away from work, and medical treatment beyond first aid. More often than not, you're probably dealing with the three bullets on the bottom, right? Restricted job duties, transfer to another job, days away from work, or medical treatment beyond first aid. All right. So now we're going to move into the fatality piece. We're just going to go through each one of those. How do you record a fatality? And we don't need to go into these into too much detail, but for purposes of kind of fleshing out how you record things on the 300 log, it's important to keep things in mind. For a fatality, don't put any day count on the log at all. You're checking the box and classifying it as a death case. G, right? Days away, we're looking at section H. Estimate at the time, right? We have 7 days to record this on the 300 log. You're going to estimate the length of any absences, days away, and then update it later. The max day count is 180 days. And let's see if, the other bullet here, the physician's recommended days away. Say an employee has a doctor's note that says you should stay at home, stay out of the workplace for 10 days. But they say, I'm good, I'm going to come back on the 7th day. For OSHA purposes, the days away should be 10 days. Okay. And that's when we talked about deference to the doctor's note. The other piece about the 180-day count, the days away from work and the on-the-job transfer restriction. So if you have a case where there's both, right? Someone's away from work and then they come back and there's some job restriction. Even if it's over 180 days, 180 days is the max between both of those. But the more severe one is the days away from work. So you're including the total number of days away from work first. And then, so this is an example, right? Say an employee was out of work for 30 days and then on job restriction for 180, right? We're still going to have 130, 30 days away from work. And then it would only be 150. All right. Yeah. Not a math person. 150 on the job restriction. Okay. So restricted work and job transfer. This is important to make this analysis. It's any restriction of one or more routine function. So this is why it's important to take a look at the job duties, do that analysis, what's on the job description sheet, what those essential functions are, and really think about those. It's work activity regularly performed at least once per week. That's the definition of a routine function for OSHA purposes. If you are restricted from working one full day, that is going to be considered job restriction, right? Does not include the day in which the incident, the injury, the illness occurred. It starts the next day, okay? Covered the health recommendation piece. Even if it's ignored, you're relying on that medical opinion for purposes of recording the day count on the log. Not recordable if restricted for only the remainder of the day of that injury, right? So we're starting the day after the incident, injury or illness. In this case, restricted or job transfer cases, we're talking about column I, And then in column L is where we have on the job transfer restriction where you're putting that day count in. Again, capped at 180 days. Clarify any potential vague medical instructions, right? This is where we're talking about, oh, light duty. Well, what does light duty mean? You have the ability to kind of figure out, well, is this really light duty? If someone has documentation that says, all right, here's my restrictions. If none of those restrictions impact their ability to do their essential functions of their job, then there is not a job restriction, right? So that's why there is this analysis of what those job duties are and what the opinion is from the medical provider. If it matches up, right? Don't lift 20 pounds and one of the job duties is to lift boxes up to 30, 40 pounds or something, stacking shelves, whatever it may be. Yeah, we're looking at a job restriction then, right? But if they don't have to do that, it's really inapplicable. It doesn't apply.
Again, guys, quick question.
Yeah.
So you said on a couple slides ago, it starts the day after the injury occurred, right?
Mhm.
What happens if the day of an injury occurs, the person says, I'm fine, and then 2 days later it says, oh man, I'm really hurt, I need to go to the doctor now. Because how does that play out?
So it can still be a recordable case, right? Depending on whether it meets one of the general recording criteria. But for purposes of whether there's days away or job restriction, we're not looking backwards. We're looking forward from when the employee informed you. Yes, okay, I was injured. If it occurred on this day, okay. But we're looking forward for purposes of job restriction, job transfer, and any medical treatment beyond first aid. Medical treatment beyond first aid. If the employee receives some medical treatment beyond first aid, perhaps, right, and didn't tell you as the employer, that's one scenario in which, yeah, this is still recordable. It's just there was a delay in you learning about that and finding that information, which is fine.
If someone was to tell you that after the fact, say the injury occurred on Monday, on Wednesday, they said, I want to go to the doctor to get checked out, would you still have kind of the benefit of it not starting until the next day, or would that first day they're going, because it's not the day that the injury count as a
So you're, well, the restricted duty or lost time, you're not going to be having, if someone's injured on a Monday and they're scheduled off for Tuesday or whatever it is, and they didn't go to the doctor on Wednesday, you're not counting that Tuesday as a day away from work, right? But we're recording on the log, say it's a medical treatment beyond first aid case, you're putting the date in which the incident occurred on there. The date in which you have knowledge of it, it's fine that it was a little late. The important piece is recording the actual information for purposes of the 300 log. That's what OSHA wants to see, right? Is that it's on there, it's accurate, it's correct. Loss of consciousness, we can kind of skip over this one. That's going to be other recordable cases, same column in which you have medical treatment beyond first aid. It doesn't matter how long the worker was unconscious, it could be for a second. That's a recordable incident, regardless of whether right, it was 1 second or they received any medical treatment afterwards. Feeling woozy, however, you're just dizzy at the workplace, that is not going to be considered a loss of consciousness. It's not recordable on that basis alone.
So this could be a case where we might not have a replacement plan because they don't want to go back there, but they passed out at work, so they were fine afterwards. You would have to report to this like that.
Mhm.
That might be something to put at points in.
Like they said, they came to work and they're like, yeah, I wasn't going to go, we have to be like. That's the thing, he has to, it's that works for like, you know, they come to work and they're like, well, I wasn't feeling good. And then I started doing my work and then I got hot and really when I passed out.
Mhm.
So we're setting up for not work.
Yeah, well, that gets into, did something in the work environment cause or contribute, right? And that's a a tough analysis, right? Because OSHA is going to look at it and say, well, yeah, there's something that may have contributed to that, right? If they're working energetic or exerting energy in their job and they came to work woozy.
It's hot outside.
It's just hot outside. Yeah.
But if they've been at work, 3 hours in the building. They're not working outside.
Yeah, maybe it's temperature control area, that's.
Yeah.
Mhm.
They're going.
I'm gonna make sure we have enough room for the first aid. Because I think
Yep.
that's the biggest thing.
Yep. Here's the medical treatment beyond first aid, other recordable case, column J there. So, right, one of the general recording criteria is if you receive medical treatment beyond first aid, anything that is not on this list is going to be considered medical treatment for OSHA purposes. So first aid, that's non-prescription medication at non-prescription strength. We get a lot of questions, right? If a doctor prescribes Tylenol at non-prescription strength, is that first aid? That is first aid. But if the doctor prescribes Tylenol at prescription strength, right, higher dosage, now we're talking about medical treatment. So that's an important nuance there. Cleaning, flushing, and soaking surface wound coverings. So there's a bunch of FAQs and interpretations on these, right? If you have something for wound closure, the steri strips, right? Dermabond, that stuff, that is medical treatment. The wound covering, we're talking about like a Band-Aid, right? Something like that. So there's quite a few interpretation letters, FAQs, which we can provide to you all that kind of cover these topics, right? Removing splinters, foreign materials by irrigation, tweezers, swabs, removing any foreign objects from the eyes with swabs, irrigation, tetanus shots, non-rigid supports, right? Like a sling, something like that. Temporary immobilization, drilling fingers and toenails, draining any blisters, eye patches, finger guards, massages, except if you are prescribed or ordered to attend physical therapy or a chiropractor from a physician, that is going to be considered medical treatment. Fluids for stress relief, heat stress relief, I should say, right? Hot days, on hot and cold therapy. So this is outlined in OSHA's regulation as what is considered first aid. And again, anything that is not on this list will be considered medical treatment beyond first aid and would meet that general recording criteria. A knee brace? Yeah, but then we might be looking at a job restriction, job transfer, right? Might not be medical treatment beyond first aid, but it might be meet one of the other general recording criteria. That's why you got to go through each one of them, right?
Would they be all embraced? So some of them are aesthetic, for example.
Yeah. What's
At least they go on to the flag. It's not all the time. But, I would think that these raised that job. It's like a
Yeah.
risk, right?
Mhm. Yeah.
Especially how supervisors are. Something to send it on, like, this is a thing that we're going to post upon.
So you're going to be relying on the medical opinion, right? But so to answer the first part of your question, no, medical treatment does not technically need to be provided by a medical provider or a nurse or anything like that. It could be provided by someone else. It's the type of care that triggers the general recording criteria, not the person that's providing
If
it.
you go to the drugstore and buy your own, you put it on. There's no medical.
Right,
Determine if it's something.
correct. Yeah. Yeah.
You guys can see where all these could be claims, right, but not in the OSHA report.
Mhm.
There could be things, they go to that.
What about on ambulance, when I get treatment, and I have to go to the doctor?
What type of treatment are we talking about?
So I said, I was kind of, I was honest, but I didn't want to do this. This is what I think it's. It took me a while.
Mhm.
No, it's first day, right? It's still be first day.
Yeah, yeah, if you're not receiving,
We're transported to the hospital, so that when we receive baby fluids, that would not, it would still be for me, because that fluids is doesn't fall under. We don't, you know, it's not.
It's-
I think they stay with you know,
yeah, an ambulance in and of itself does not necessarily make it more than first aid. Right?
What happens?
It's what happens. Yeah, it's what happens.
Yeah, or if they take them and admit them to the hospital, or. If
Right.
It's not, the ambulance isn't kind of a threshold on.
Right, even if they admit you to the hospital, they don't do anything, it's still. Just do diagnostic. Just do diagnostic, yeah.
Yeah. So that gets onto the reporting piece. If you get admitted, the only way you're not reporting it is if it's for observation. Observation. But on the reporting side of things, and this is a key distinction, if you receive any care or treatment, it doesn't have to be medical care or treatment. Right, it's not the medical treatment beyond first aid analysis. If they're doing anything to you after you're admitted into the hospital other than observation or diagnostic purposes, that is care or treatment. For reporting purposes, it's reportable. Right, so it could be an IV, right? It could be antibiotics, an IV, whatever, very minor care that might be considered first aid. No, it doesn't matter in the reporting context, whether it's beyond first aid or not.
Did you have a reportable, but it never turned into an open?
A reportable incident that is not recordable? That's a good question. I mean, I suppose,
If they admit you do diagnostics, you can't
Yeah.
find anything that send you home, you don't have to follow that. Right.
right, you,
I'm saying, if they admit you do diagnostics and then release you, it's not.
that's not,
Because you're just doing diagnostic.
yeah,
I thought it was the admittance, not the work. You're getting for observation or diagnostic.
yeah, that's not reportable. Okay, so we got 20 minutes to get through a bit of material here, so we're just gonna cruise through some of these minor areas. Special recording criteria: significant injury or illness diagnosed by a doctor, licensed healthcare professional. This is your broken pinky, broken toe, that you're not receiving any medical care, treatment, right? They just say, all right, wrap it up. Take it easy for a couple days, right? But you might not be restricted in doing anything, any of your job duties, whatever that might be. That's one of those special recording criteria. Minor finger, break, or your pinky toe. Tuberculosis, any occupational hearing loss, medical removal pursuant to one of the special standards like lead, where you're ordered to be removed from the workplace because your blood levels are so high, or any needle sticks or cuts from sharps contaminated with blood or potentially infectious material. That's recorded in column J. All right, so we already went over the verify, summarize, certify, and maintain the injury and illness record keeping logs. At the end of the calendar year, we're reviewing everything, right? The 300 logs for accuracy, making sure that the data is accurate on the 300A, certifying that, and posting it from February 1st through April 30th, right? Keeping and maintaining and updating the 300 logs for the 5-year period, but retaining all of the injury and illness record keeping records, 300, 300A, and 301 forms for that 5-year period. Certification by the company executive, right? This can be basically any high-ranking official at one of your stores, perhaps, if they're responsible for doing that, they can certify it, or it can be someone from corporate EH&S. So mention this already, the only important piece that we have to cover here, you don't need to update those 300A and 301 forms over the 5-year period, just the 300 log, but you need to maintain them.
I just have 301 question really quick.
Mhm.
I can't find any documentation that says that there's any thing not filled out on the 301. Is every field on the 301 required? The doctor's name, the medical provider, their address and name, is all of it required?
Yeah, so the information that each item on that form needs to be filled out.
Okay, so everything's required on the 301.
Yeah, each section. Yep. Recording COVID cases, we don't need to cover this in too much detail. It's basically the same analysis. It's good. You have to have a confirmed case of COVID, right? And it needs to meet one or more of the general recording criteria that we just went over: medical treatment beyond first aid, days away, death, restricted work, job transfer, one of those, right? Usually it's days away or medical treatment beyond first aid, right? The work-related analysis is really the trouble piece that employers have been dealing with for a while now. But basically what we've gathered is, right, if there's several cases amongst employees, you have a cluster of cases, an outbreak, and there's no alternative explanation for why that employee has COVID, right? They weren't at the bar all weekend, or, you know, somewhere else, or a family member had it, right? More likely than not, something in the workplace caused or contributed to them getting COVID. Infections after a close contact at work. And we're just going to look at the job duties, right? Seeing if there is an alternative explanation for why they got COVID. And this is just a flow chart that you'll get in all the materials we provide. So we already went over all these record keeping mistakes, and we'll include these in the material. So we're not going to go over them. Like I said, failing to update the log within 7 calendar days, failing to complete the 301 incident report for each item on the 300 log, replacing an employee's name with privacy case if the recordable incident is a privacy concern case. Those are cases in which we're talking about, you know, someone may have a needle stick, HIV issues, injuries to sensitive areas of their body. Failing to properly describe the recordable incident in the 300 log itself, including any extraneous information. So inflammatory language, crushed, you know, when we're talking about describing the nature of an injury, say someone fell, right, from, you know, a staircase, fell on the staircase. Perhaps you don't have to put fell on the staircase 60 feet, crush their head, right? It's just fall on stairs, injury to head. Like very basic and kind of the minimum of what's required.
So when I ask people the employee statement, a lot of times I see from, you know, from a finger off.
People at the work site are,
Yeah, they're put down in the employee statement as the quote. It's
Yeah.
not necessarily what it's on.
that's not what you need to put on the log. Yeah. Yeah, what's in the employee statement, that's fine. That adds some color to the incident, but you don't need to provide that color for OSHA, right? In your injury and illness records. Yeah.
So let's say you have an employee who has hearing loss.
Mhm.
And it's documented in 1 year, so you have to document that report that every year after that, because they'll get tested every year. And every year they'll come up as hearing.
So we're talking about a standard threshold shift under the noise hearing conservation program. Yeah, so those are handled especially, right? Let's talk after about how that works, just for purposes of getting through this stuff. But we did have some pieces to run through a quiz here, but I think we'll have to bypass this part for now. But you're going to get all of the information and the responses to this for how this works. But we need to get on to the reporting section of this so we can cover that as well. So let's pull that up. All right, so now we're on to the reporting side of things. We've already covered this a bit in the record keeping section, but what do we need to report? There's 4 things that we're talking about: a fatality, the hospitalization of 1 or more employees. What does that mean? Inpatient admission for care or treatment. amputation, or loss of an eye. So a fatality needs to be reported to OSHA within 8 hours of when you as an employer have knowledge of that fatality. It doesn't necessarily need to be 8 hours from the incident, right? Because there may be a delay in when you find out and confirm that there may have been a fatality, right? But once you have knowledge, the clock starts ticking.
Then I think, so, and someone's, if you have a fail at work, you don't know why, could be medical, could be work, do you report it anyway?
So if it's like
Obvious,
someone that has a non-work related condition, right? Say they have epilepsy or something like that. And they have,
following their death.
yeah, the geographic presumption applies, and that is technically reportable at this point, right? We have a fatality in the workplace. Geographic presumption applies, it's work related, unless you have knowledge at that moment otherwise. It's tough to not make that report, and it's going to be tough to make that explanation to OSHA as well, if you get a late report of sight, right?
You have 8 hours though.
You do have 8 hours to try.
You can probably, in the reason probably about 8 hours, doesn't necessarily be going to be horrible, but in that situation, you don't have it, there's no autopsy being done for days, you know, you're not gonna have that kind of clarity.
Yeah. And you may get clarity afterwards and you can update that report. Certainly, but the clock starts ticking of when you have knowledge, right, of a work-related fatality. So we have to move somewhat fast. 24 hours for amputations, loss of an eye, or a hospitalization. 2 ways in which you can make those reports: by phone or on the web. We do not recommend using the online reporting system for a couple of reasons, right? Anything that you put in writing, one, it's subject to potential FOIA requests, can be accessed by the public. Personal injury attorney, if there's a potential tort case, can be used by anyone, right? Grab through a FOIA request after the inspection is concluded. Of course, there's an exemption under FOIA for active enforcement, but once that case is over, it's available for anyone and everyone, right? Electronic security risks, and you're kind of boxing yourself into information that you provided at that time in writing. When you make the phone call, it is, again, probably someone that is an intake person, depending on whether you call the 1-800 number or the area office in the jurisdiction where it happened. And they're just collecting information, jotting it down, and they'll call back later. So it's just their notes, right? It's not your written words that are going into paper form and submitted to OSHA. What is the information that actually needs to be reported? This is it. What you see on the side, and it just needs to be bare bones. The establishment name, location of the work-related incident, what type of reportable event is it? Fatality, inpatient, hospitalization, amputation or loss of an eye, number of employees who suffered the event, name of those employees, who that employer contact person is going to be, right? The point person for communicating with OSHA, and then a brief description of the work-related incident. Don't have to identify a root cause. We see this a lot where employers are quick to do a root cause analysis. What you're doing is giving OSHA a roadmap of potential violations, right?
This is true for the state of Virginia.
Yeah.
Because I was grilled for 45 minutes by the inspector very recently.
Mhm.
I just kept answering information, I don't know,
Yeah.
because I didn't know.
You were well beyond that.
Well, beyond this.
Yeah, well, when you make the initial report, this is all that you need to provide. If you're reporting during the day and someone answers it right at the local area office or in state plan, they're gonna try and get more information at that time. But if you're reporting after hours, a lot of times, right, we have 8 hours, we have 24 hours. It's nice to report when OSHA's not open. Give yourself a little bit of time before you know they're gonna show up, right? If you call them at 8 a.m., they might be there at 10 a.m. If you wait until, the incident occurs at noon, perhaps it's a fatality, right? You don't call till 6, it's fine. And they're closed and they're not gonna.
Happen on call, record reported and you never got a call back. Whereas when we do electronically, you do that bounce back if you submitted something.
Yeah,
So that's good recommendation not to use the form.
mhm. Yeah, that'll be in the inspection file.
Just make note of it too, though. If you're going to make a phone call, to make your own handwritten note. I call
Mhm.
this number at this time, like from my cell phone, from my office, from my cell phone, so you know what number we're getting. And then if there's a finger point, you know, if you never call, you never call, the voicemail got to leave. And when we can get it, we can look up the volume record.
Yeah.
But just, you know, so verify it yourself, you're operating with the last, we can take care of a figure point.
So the inpatient hospitalization piece, what does that mean? It's formal admission to the inpatient wing of the hospital for care or treatment. As we discussed, doesn't include admission for observation or testing, diagnostic purposes, doesn't require an overnight stay. So even if you're admitted as an inpatient just for an hour, 2 hours, 3 hours, whatever it might be, and you receive some type of care or treatment, that is what is going to trigger that report. Obviously, there's confusion about what's admission, right? People think, oh, I'm admitted to the hospital. They might be sitting in the emergency room. So we get confirmation that there was admission to the inpatient wing of the hospital and try and track down that information from the employee. Yes. Yeah, I mean, you're probably in discussions at that point with the minor's parents. If they're an employee, yeah.
And that does get very confusing though, because we had someone that we thought was a very pediatrics, but they're also in pediatric arts.
Mm.
So it's very messy.
Yeah, you just got to be careful when you hear, oh, I've been admitted to the hospital. Well, what are we talking about?
People we try to talk to and get the stores to get information from the person. Difficult for them to get it right.
Yeah, certainly. Yeah, it's a challenge for employers, and there is kind of a gap there in collecting the information. And that's why it is 24 hours from when you have information that triggers making that report, right? So when you might be past 24 hours from the incident that may have sent an employee to the hospital, if you can show to OSHA, hey, I made these phone calls, we reached out, we tried to get this information, that goes a long way in the inspection if they're looking at a reporting issue. Whereas if the employee goes to the hospital on a Wednesday and you don't do anything and you make a report the following Wednesday, and you can't say to OSHA, oh, I made these phone calls, I tried to contact the employee, we even visited the hospital, OSHA's gonna say, well, what did you do? What type of due diligence did you do? If you didn't do anything, you're probably going to get a late reporting citation in that case, right? So do your due diligence and trying to gather that information as quick as possible. Yep, yeah, so it does not require an inpatient admission for an overnight stay. It's just an inpatient admission for care or treatment, regardless of how long that is. That occurred. Yep. Amputations, this also gets a little confusing. It's the traumatic loss of a limb or an appendage that's been severed, cut off, amputated, either completely or partially. The issue here is whether there's an avulsion, just the removal of some skin. We're gonna be relying on the medical provider's determination here, and there's no problem asking questions too, right? If you don't think that maybe this was a partial amputation, asking the medical provider, is this really what we're talking about? Likely they're not going to change their initial determination there, but you can certainly ask questions.
And I just have a client within the last week or so where it was diagnosed originally as an amputation, and he tried to get clarity because he wasn't a whole of it. and the 24 hours full. And so we reported it. And then after that happened, the doctor got back and said, oh yeah, you know what, I agree, this is the ball. And so, you know, the unfortunate part there was we had already made a phone call, you can't rewind that. So if you're gonna follow up.
Mhm.
One that comes up often too, it's the amputation where you take your whole fingernail like that. It's technically an amputation, right? Is it otherwise? And
The loss of a fingernail.
yes, it's just so amputations is considered an amputation.
Uh,
If that happened.
I think the loss of a fingernail is not going to be an amputation. I'm pretty sure that's outlined in the FAQs as well. We'll pull that and yeah, we'll look into that for you as well. There might be. Yeah. Medical amputations, that's also included. Couple items, things that don't need to be reported. This may be applicable to drivers, right? Fatalities or injuries that result from a motor vehicle incident on a public road. So there may be instances where something's recordable, but not reportable, right? So that's recordable there as a condition of employment, maybe work-related, right? But it's not reportable because that's one of the exceptions outlined in the regulation. Fatalities or injuries that occur in a motor vehicle accident on a public road, except in construction work zone. Fatalities that occur on things like planes, buses, trains, diagnostic testing or observation only, we covered that. And then if you're going to the hospital for outpatient care or treatment, and you're not formally admitted as an inpatient, that's not reportable.
Uber and taxis, your plane subway.
I believe so. I don't think there's anything on Ubers and in that sense, but it's a public form of transit. So I think OSHA would look at that the same way as a bus or something like that. So a couple important time periods here, and this is very, very important. So you're not over reporting. So you have to report within 8 hours of when you learn of a fatality, right? And you have to report within 24 hours of when you learn of an inpatient hospitalization, amputation, or loss of an eye. Now, these things are only reportable, right, for a fatality if that fatality occurs within 30 days of the incident. Okay, so there's two different time frames that we're looking at here. When we're talking about an inpatient hospitalization, this is where it comes up most often. That inpatient hospitalization, so admission to the inpatient wing for some and receipt of some type of care or treatment, that has to occur within 24 hours of the incident in the workplace. So if someone isn't admitted to the hospital for 2 or 3 days after the incident, it is not reportable regardless of whether they're admitted, right?
So if they sit in the emergency room hallway for 2 days, and then they put them in a room, and then you don't have,
Not reportable.
that's real life.
Yeah, so that's an important time frame. So you're not over reporting and something that you definitely want to look at when you're doing your due diligence and finding out the status of an employee in the hospital or that was sent to the hospital. Same thing for amputation or loss of eye, has to occur within 24 hours. So a medical amputation that's perhaps scheduled for a week later, or it occurs 2-3 days after the incident, not reportable. We covered these reporting timing issues, so we don't need to cover these in too much detail. Here's the final 7 or 9 common reporting mistakes: over reporting hospitalizations that we just talked about, premature reporting before you have any actual information. This is often where we see employers say, oh, well, they were going to the hospital, so we just called OSHA. That's what we thought we were supposed to do. That's not the case, right? Make sure you're doing your due diligence to get that information, to do the analysis. Couple different ways OSHA can respond, right? The rapid response investigation, they could come out on site. But if we're talking about our response to OSHA, or if we're having the conversation with them after a report, perhaps, right? We don't want to focus solely on blaming the employee, even if it is a employee misconduct issue. They violated our policies, our rules. There's different ways to explain that than just saying it was the employee's fault, right? eloquently explaining it in a way that's, we have policies in place and programs to address these hazards. Employees are diligently trained on these. This was an aberration from our standard policies. Here's what we're going to do to fix it, right? Responding to OSHA that way in the RRI response gets them to say, all right, they already cover this, but they're willing to do more. We can close the book on this one. We're not going to go out and inspect it. Whereas if you just say, this was the employee's fault, can't believe they did this, OSHA's going to come out and say, oh, maybe there's a fault here, some miscommunication between the employers. We're going to go look at it, right? Failing to report minor fingertip amputations, right? It can be anything, doesn't need to be bone loss. Reporting non-employee injuries. So again, you only have to report injuries, fatalities of your employees. Making the report through the online system, again, make the phone call. Making the courtesy report, that kind of ties into the over reporting or premature reporting. Don't just do it because you think you have to. If you don't have the information, you don't have the information yet, but you're trying, that's okay. Making verbal or written admissions in any type of report or response. Again, the root cause analysis is great in theory, but it's not something you want to provide to the agency, because again, it can provide them a roadmap of potential violations and things that you're admitting, right? And then failing to document efforts of learning at the employee status.
So when the RRI form asks for cause, it asks for your root cause of it, I mean, so how do you do that?
Yeah, so I mean, there's ways to investigate an incident without calling it a root cause, right? We can identify potential areas to make improvements on without saying this caused or contributed to the incident. And we're typically not going to make a determination of that root cause for 6 months and 1 day, right? If you are making a report, do not finalize that report, right? It's going to take a while. OSHA might ask for it early, but you can say the incident is still under investigation. It can be under Yeah.
For the purpose for an RRI, you need, obviously, you don't.
Yeah.
Give them something that is, as far as you can tell, is pretty obvious that you don't need to go through the process of saying, find why. Well, this happened. Why? Because this happened. I've identified 5 system failures, which led to the end result that a box fell off the top shelf.
Yeah.
Right? It's box fell off the top shelf. We're gonna push them back 6 inches from the lip moving forward, or put an edge guard on, right? It's not, someone knocked off the guard, someone didn't replace the guard. You didn't train enough, or we didn't audit enough to know that the guards weren't put in place. It's looking at it, not necessarily root cause, but I'm getting to an identifiable cause that I can also offer corrective action for that I can. Not all of my theories and all of my thoughts and all of my potential avenues and how I got there. And this may have occurred and everything like that. So it's identifying more of a conflict, and especially in that point time. We haven't probably done a root cause at that point, but it's looking down, giving something that we can identify, perhaps we can provide to the agency as opposed to an absolute conflict.
Yeah.
Mm-hmm.
Yeah, this is done on the reporting piece. This, we've already gone over kind of the response, the RI piece, whether OSHA shows up. And these are just some of the factors and what goes into consideration of that. Best practices, we went over that. And then the last piece is just the e-record keeping portion. Back in 2016, 2 key requirements, right? 250 or more employees at an establishment, you had to submit your 300A annual summaries, 300 logs, 301s. Workplaces in those high hazard industries, Appendix A to the rule, had to submit their 300As. No one had to submit 301 or 300 logs at all. They got rid of that that requirement formally under the Trump administration. We don't need to go over the coverage here or the employee count. the applicable employee count, right? It's peak employment at the time of the year, including all your seasonal, hourly employees, part-time employees, temps, whatever that may be. The new information that you need to know is there's been an update to the rule finalized just this past spring that reintroduced that requirement for certain select high hazard establishments to submit all their injury and illness records. So the 300, 301, 308 forms that was finalized in July. It's going into effect, maintains the requirement for those high hazard establishments in Appendix A to submit 300A data, and larger employers with 250 or more employees at each establishment to submit 300A data as well. So that's the outline of this new amended rule here. A little disappointed. It was kind of more restrictive than what we actually thought it was going to be, or impose more requirements on employers. Those requirements to submit the 300, 301, and 308 data, it's 100 or more employees at establishments covered in select NAICS codes. So that's new Appendix B, and we'll take a look at that, or it'll be in all the materials here. This is just an overview of the enforcement history of the rule. So mostly failure to submit data altogether. There's anti-retaliation elements in there as well. That's a very minor piece. That's kind of executive compensation, post-incident drug testing, or retaliating against employees for reporting workplace injuries and illnesses. This is the most important piece that we should cover, the SST program. Like I said before, we covered this as well. Basically, if you are subject to OSHA's e-record keeping rule, you can be subject to an SST inspection at any time, regardless of how good your establishment's injury and illness data is. It's comprehensive. It's a wall-to-wall inspection. And there's nothing you can do about it. That was the whole purpose and genesis of creating this rule, to collect data, to use it to analyze high hazard industries and target employers for inspections. So that is a quick overview of the e-record keeping rule. The only other piece that we could talk about is editing data submissions. We get this question a lot, so I'll cover it briefly here. If you have data that either you forgot to submit or it needs to be revised, you can do so. It needs to be revised on the portal. You just submit it again. You basically make a resubmission. If you didn't submit it by that March 2nd deadline, and we're talking in late September, you're past the 6-month statute of limitations, and the portal's probably already changed. So the only way that you're going to be able to upload that data, even if it's very favorable, is by picking up the phone and calling OSHA and bringing attention to yourself that you didn't comply with the rule that you now can't be cited for anyway. So long story short, don't do it. Don't make that phone call. But that is the only kind of key piece I wanted to highlight here. To get past that 6-month statute of limitations, and there may be some faults in the records, just let it go.
So are they going to provide the directions from January on the requirements? Yes, I am wondering how happen to 301s and
Yeah,
extra stuff they're asking for. Yeah,
we would expect them to. Yeah. There's no instructions or updates on the ITA system. It's supposed to be rolled out for the next year, right? By March 2024. There was problems with the last go around, right? In 2016, when the rules formalized and they kept extending it. So there hasn't been an update on whether the portal is even set up correctly to do that. So I'm not saying that there's a potential that you won't have to, but there could be. Yeah. It might get delayed. But prepare as though it will be coming, right? So getting those records in order, so you're not scrambling at the end.
Recent conversations.
Based on the next codes. Yeah.
Based on the next one. Say like offices per se that. Like it's like very honest. Prior to slow, things like that. That's not.
Okay. Yeah, so that's really everything that we wanted to cover here. So we'll send, I know we didn't cover some of the slides in too much detail, but it's all included in here. And if anyone has any questions or wants to discuss particular issues or record keeping issue that might pop up, feel free to give us a call and we'll help you out with that. There's a lot of the gray area that we're in the weeds in a lot, as you all are, but we know where to go and help you guys track that answer down. So